I'm Jennifer Crumbley.
James Crumbley.
Awaiting their fate, today is the sentencing for Jennifer and James Crumbley for their roles in their son's 2021 mass shooting that took the lives of 4 students at Oxford High School. This comes as attorneys for the couple have asked for less than 5 years in prison ahead of today's sentencing. Good morning and welcome to our special coverage of the sentencing for Jennifer and James Crumbley, the parents of the Oxford shooter. I'm Meredith Bruckner. The sentencing hearing will likely be a long and emotional day as the victims' families will be able to address the Crumbleys for the first time. And this will also be the first time Jennifer and James Crumbley will see each other in court in more than 2 years, and a lot has unfolded since then. CBS News Detroit's Kelly Vaughn provides us with a preview of what to expect this morning.
Most recently, James Crumbley's attorney responded to jailhouse phone calls where James was heard threatening the Oakland County prosecutor. Crumbley's lawyer now saying it wasn't threats, he was simply venting.
Certainly has a constitutional right to be stupid, which he was in abundance. So, whatever he vented, as she put it, can and will be held against him, as they say.
Former federal prosecutor Rick Convertino says the sentencing hearing will also be James and Jennifer Crumbley's first time together since sensitive information about their relationship was revealed in each of their trials.
Some of the evidence that came out was pretty egregious. You had Jennifer meeting guys at the dumpster behind Costco and or whatever website she was on, Adult Finders or some nonsense. And she was carrying on pretty heavily, and that came out in trial. James was not much better himself, and he seemed to live an independent life that was kind of nonplussed by the activities of his son or the pleadings of his son for help over and over and over. So there's probably not much left there in that marriage, if there was at all.
The two are the first parents in the U.S. to be sentenced for a mass shooting committed by their child. They face up to 15 years in prison for each of the 4 counts of involuntary manslaughter. Convertino says the defense should be reasonable in their requests for sentencing.
You don't want to, shoot for the moon in sentencing, and like this one defense attorney did, and ask the judge for her client to live in her guest house. I mean, it is beyond preposterous, absurd, ridiculous, stupid. It's nothing that a judge would ever consider.
He says victim statements from family and loved ones will be impactful in sentencing.
And it's going to be a really, really tough day for the victims and their families, because nothing regarding the sentence is going to give solace or comfort.
We now want to bring in our legal experts who have been with us from the beginning, attorneys Lillian Diallo and Rick Convertino. Thank you so much for being here. So Rick, we'll begin with you. What can we expect today?
I can expect a lot of emotional testimony from victims and families who are going to tell the court the impact that this heinous act had on them individually and collectively. You're going to hear the judge. She takes into consideration all of the information that she's been provided in the sentencing memorandums from all 3 parties, including letters of recommendation, letters of conduct, all sorts of information that she's compiled through the pleadings. And so it's going to be a long day. It's going to be a hard day, emotional day. But there is nothing that will be resolved in this sentencing by way of solace or grace that they can take away, the families and the victims can take away from this, because that pain will continue on for lifelong, for their lives.
Mm-hmm. And Lillian, this was for me personally, the hardest thing to watch was the shooter sentencing and hearing from these families right off the bat. Incredibly emotional testimony.
And it's going to be, I'm sorry, it's going to be. So everybody needs to understand, everyone in that courtroom is constitutionally mandated. So the defense attorney, the prosecutor, and the judge, everybody is constitutionally mandated, but it's going to be tough. It's going to be tough because the parents, the families, the people that love, and they will always be loved, right? They're not going to, this is not closure, and I hate when people say that. This is something they're going to get through, but never over. So we'll see how it goes, but it's going to be very difficult.
That's a good point. Something they'll get through, but never over. I don't know if we can have a live look into the courtroom now, just to get a look. It's certainly filling up. We can see the defendants and their attorneys there. Now, something that was perhaps surprising in the sentencing of the shooter is that we did hear from the shooter. Is that common to hear from defendants in a sentencing?
Yeah, you can hear from the defendants. Will be allowed to address the court in this sentencing, and I would anticipate that they will, to try and mitigate the sentence that'll be meted down to them. But they'll have the opportunity to address the court, as Lillian said. It's a constitutional obligation that the defendants have a right to speak regarding their sentencing.
So at this point, they've already been convicted, but this is sentencing. I mean, do you think that's the correct thing to do, Lillian?
I don't know, because they still have an appeal. What can they say other than what's already been said? So they have an appeal, and their words can be used against them later on. What can they get from speaking other than saying, I'm sorry? God knows we don't need Jennifer saying anything else that might turn things more unfavorably against her. And then when we hear from James, he was more sympathetic until he gets to the jail. And we hear the jail calls where he's threatening, an official, that you don't help yourselves. Their words are not helping them. So they need to rely upon the sentencing guidelines and ask the judge not to exceed the sentencing guidelines wherever they may fall.
And something you mentioned, your words can be used against you in the appeals process. That's something that may happen with the shooter, because what he said, his statement felt very unscripted. It did feel emotional. He said in his sentencing that he and only he was responsible for this. His parents had no idea. And I'm sure attorneys here in this case wanted to use those words, but they cannot.
Right. And so let's understand this. I believe his words were trying to help him in a way, because the lawyers that he pled guilty to every single thing. So the grace that you would have is going to be something at sentencing, right? And we heard the Miller hearing. But understand this, he was a child, right? Children and their parents. So yeah, he loves his parents. He might be trying to save his parents, right? But ultimately, it is the parent's responsibility to care for the child, and not the child's obligation to care for the parent, period, until they're of age.
We're seeing close-ups of the victims' family members, of parents, of Justin Schilling and Tate Myers there. We've seen these faces from the very beginning. These parents have been incredibly strong, incredibly vocal. They've not backed down despite how difficult these hearings and these trials are. Just, Lillian, talk about what they must be going through.
It's just pure anguish. You have to relive this. You have to look at the people and think of what could have been, right? They don't want to sit in that courtroom. What could have been if you would have said, okay, I'm not going to buy you this 6 hour, right, with your money. I'm not going to do that. You have access to other guns, but they would not have been as lethal, right? What could have been had the school paid attention? Because apparently some of the children in that school did, because I remember an interview where one of the young men, and I don't know, they scrubbed it from the internet, but we watched it, said there was a countdown clock. We don't know how accurate it was, but some kids zoomed in that day. So if the children knew, why didn't the adults? Adults have an obligation. And as a teacher, as a parent, as an adult, we are responsible for these babies, for these children. And nobody took the responsibility. Everybody was in their privilege at that moment, right? That child should have been out of that school. Take the kid's book bag, right? Look in the book bag. You'd have looked in my purse. Look in the book bag. Do something where these kids should not be dead. And they were killed in such a brutal fashion, right? So we're going to have to sit here. We're going to watch the parents try to have as much grace as they can, but there's going to be raw emotion, and it's going to be very difficult. And viewers need to understand this is what happens at sentencing.
Do you think we'll also hear from survivors
I think so.
attack?
I think in one form or another, either directly or in memorialized form. I just want to take a brief moment to talk about the sentencing guidelines just briefly. The sentencing guidelines typically, and I'm curious if you'll agree with me, Lillian, that typically the parties, when they're arguing for sentencing, are within a guideline range. Both parties are accepting the guidelines, but are maybe one or two things. And so you have the defense typically arguing for the lower end of the guidelines and the prosecution arguing for the higher end, but they're still generally within the guideline range. Here you have a huge disparity between what's requested or what's calculated as a guideline range by the defendants. You have one defendant asking for her client to be sentenced to, live in her backyard. You have another defendant asking for 28 months to 43 months, and you have the prosecution, based on their sentencing memorandum and their calculation of the guidelines, asking for a sentence of 10 to 15 years, so the maximum amount under the statute. So huge discrepancy.
And I'm just looking at the court now quickly. Are the defendants going to be sitting directly next to each other? Is this how this is going to be set up?
They'll be next to each other, but not, I think they should probably be spaced. So
Okay.
You're next to your lawyer, you're next to your lawyer.
Okay, because that's what we've seen. That's what we've seen in the past. But really full courtroom there. This seems to be fuller than previous cases in this case. You're watching our special coverage of the Crumbleys sentencing. We have to take a break, but you can watch uninterrupted coverage of this hearing over on our stream with the CBS Detroit app or on our website. We'll be right back. To our special coverage for the sentencing of Jennifer and James Crumbley. We now want to take you into the courtroom as things begin. When the sentencing hearing is taking place there in Pontiac, we do want to warn you there may be images and language that may be disturbing.
Court is now in session. The Honorable Shirley Matthews presiding.
Good morning. You may be seated.
Your Honor, calling People v. James Crumbley, case number 22-279-989FH. Calling People v. Jennifer Crumbley, case number 22-279-990FH.
Good morning.
Good morning.
Marquise on behalf of People.
Karen McDonald on behalf of People. Good morning, Your Honor. Mario Lehman on behalf of James Crumbley, who's seated to my right.
And good morning, Your Honor. I'm Shannon Smith on behalf of Jennifer Crumbley.
Good morning. You may be seated. I want to tell you that I became ill last Friday, and I've been taking medication for the last 5 days. I feel fine. My doctor says I'm no longer contagious, but I have a lingering cough that is sure to annoy everyone in this room. I determined my cough would not be as annoying as adjourning the sentence, so you have my apologies. All right? I know this is an emotional day for everyone, and I want to say that I have, I want to ask first, Mr. Crumbley, can you hear?
I can.
Okay, all right, I want to make sure. The court has reviewed the pre-sentence investigation with regard to each defendant and the sentencing memos provided. With regard to defendant Mrs. Crumbley, have the prosecutor, Ms. Smith, and defendant Mrs. Crumbley had the opportunity to read and discuss the pre-sentence report?
I have had the opportunity to discuss it with my client, and we do have a few objections.
Okay, you're
There's
getting
one correction.
You're getting ahead of me.
Sorry.
All right. It's a little unwieldy with everyone here, but I just want to make sure that you went over the pre-sentence report. The prosecutor has had that opportunity as well.
Yes,
correct?
sir. Thank you.
All right. And with regard to defendant Mr. Crumbley, have the prosecutor, Ms. Lehman, and the defendant Mr. Crumbley had the opportunity to read and discuss the pre-sentence report?
Good morning, Your Honor. I have had the opportunity to review the pre-sentence investigation with Mr. Crumbley.
All right. And then with regard to defendant Mrs. Crumbley, do you have any corrections, deletions, or additions, both the prosecutor as well as defense counsel? But you may go ahead.
Thank you. The only correction we would have, Your Honor, is that actually on the very front face sheet, it indicates that Ethan Crumbley is a co-defendant, and I would ask that he be taken off in that regard.
Well, he's not. I think probation has addressed. I've discussed this with probation. Ms. Wheeler, what is your suggestion with regard to the pre-sentence investigation? He clearly is not a co-defendant.
That's correct. And in the PSI, he's listed as a related defendant, which is the best phrase we could come up with. But I'm comfortable if we want to move that to a condition 9.01.
Okay.
And then it would list him as a co-defendant, but it was still requested no contact order.
Okay. Are you each satisfied with that? He's a related defendant, correct?
I'm satisfied with that, but I would ask the court to hear our objection as to the no contact provision later.
Sure.
Thank you.
Sure. All right. No other corrections, deletions, or additions, correct?
Correct.
All right.
Not for Mrs. Crumbley. Thank you.
All right. Prosecutor, with regard to the pre-sentence investigation, with regard to Jennifer Crumbley, are there any corrections, deletions, or additions to the pre-sentence investigation?
No, yes, thank you.
All right. And with regard to Mr. Crumbley, are there any corrections, deletions, or additions to the pre-sentence investigation?
Yes, Your Honor. There are some corrections. Again, on the cover sheet, the cover sheet of the PSI report does indicate that Mr. Crumbly's son is a co-defendant. I understand that that's going to be changed.
Correct.
We're satisfied with that. Also, on page 1 of the pre-sentence investigation report, there's an indication that Mr. Crumbley has a substance abuse history. He indicated during the pre-sentence investigation that he has used substances, alcohol, marijuana, but not a substance abuse history. So we would ask that the PSI report reflects that Mr. Crumbly does not have a substance abuse history. It's just simply a box checked yes, Your Honor.
Well, I guess I'm going to ask probation to indicate why they checked that box, but from what I read, he indicated that he used marijuana daily, and I didn't read that there was any medical purpose. There's also some support for large volumes of vodka and whiskey being purchased in a 1-month period. So,
Your Honor, I am so sorry, if I may. I did not realize it says yes in the box for Mrs. Crumbley with regard to alcohol use. I didn't know we were going to get into the substance, but those purchases were all made in November, right before Thanksgiving, right before the Crumbleys hosted extended family and people for the holidays. So to use those receipts that the prosecution attached in their memo that were not even part of trial is unfair, and my client also denies having an alcohol abuse history.
Well, they weren't part of the trial because I excluded them.
Right. No. Well, the alcohol purchases, you had excluded the photographs with the alcohol bottles.
I believe 2 years ago there was a request by the prosecution to introduce evidence that the Crumbleys had made large volumes of purchases at a liquor store close to their home. And I don't think at the time the prosecutor was able to link those party store purchases to alcohol. So at that time, 2 years ago, I believe I excluded that at that time. But I'm going to allow the prosecution as well as probation to address that.
Just the last comment from the court judge, that's correct. I think it was June of 2022. And regarding the purchases themselves, counsel put in photographs of that Thanksgiving dinner. There were 6 people there. The evidence supported by the prosecution shows 18 different bottles of whiskey and vodka over a 26-day period, Judge. It's factual by preponderance of the evidence that occurred. I believe probation can better articulate the reason why the box substance abuse was checked, but it appears just from the factual information, that's why we checked yesterday.
Ms. Wheeler, would you like to address that?
Judge, I agree with Mr. Keese. The alcohol purchases were not put into the PSI because we were not aware of those at the time the PSI was prepared. I believe with Mr. Crumbley, he reported daily marijuana use without the use of a medical marijuana card. And in addition, Mrs. Crumbley's use is outlined in the narrative, and I think that justifies substance abuse history.
Your Honor, I would object if substance abuse, any substance abuse was in high school, and there certainly is not drug abuse. So she's listed as yes for drug abuse, yes for alcohol abuse, and yes for substance abuse. We would be objecting to all 3, but the probation department hasn't even said anything with respect to Mrs. Crumbley and drug abuse.
Would you agree that drug use should be stricken?
Judge, it says that she first tried marijuana at ages 16 and alcohol at 19, used marijuana occasionally until 2020.
Okay, well, occasionally doesn't sound like drug abuse.
Sure, Judge.
I mean, for some people, I guess. So I'm going to strike drug abuse as it relates to Mrs. Crumbley, but keep substance abuse and alcohol abuse as to both in the pre-sentence investigation. All right? So what else?
Yes, Your Honor. Also, and this is a little nitpicky, Your Honor, but on pages 2 and 3 of the basic information report, it lists the sentencing date as April 9th, 2024 at 12 a.m. Obviously, the court is not open at 12 a.m. We would just ask for the
Well, I would be if I could.
I know you would, Your Honor.
Yeah. All right. Yeah. That's a computer issue,
Yeah.
right?
I don't
Sure.
actually think we can correct that at this point.
Okay.
It's a computer program.
Sure.
Your Honor, in Mr. Crumbly's criminal history, each offense lists an arrest date. Mr. Crumbly maintains that he has been arrested twice, including for the instant offenses. Specifically, record 7 of 8 of Mr. Crumbly's criminal history in the pre-sentence investigation report indicates that Mr. Crumbly was arrested on August 29th of 2017 by the Oakland County Sheriff's Office for failing to display a valid license. I did review the Detroit District Court Register of Actions online, and in fact, it indicates that the citation was dismissed on August 29th of 2017, that the citation was issued on August 9th of 2017. So I would ask that the record 7 of 8 correct that Mr. Crumbly was arrested on August 29th of 2017. That's not accurate.
Probation.
Judge, I don't have an objection to striking that, but we do often put in district court arraignment dates under arrest date.
Okay.
That helps us when we score PRV 6 going forward as at time of events. But I don't have an objection to taking that.
All right. So the arrest date, Ms. Lehman, is August 9th, 2017. That's what you want.
When the citation was issued, right?
Okay.
Correct.
All right.
As it relates to substance use, Your Honor, and I should have said this a few minutes ago, in the PSI report, it indicates that Mr. Crumbly was using alcohol and marijuana from 1997 to 2021, but that's not accurate. During the pre-sentence interview, Mr. Crumbly was asked when he first used alcohol and marijuana, and he indicated it was 1997. So I would just ask for a correction, that it wasn't used that whole time, that it was a first use, and that it was And then Mr. Crumbley first used marijuana at 21, then not again until it became legal in Michigan, I believe is what the indication was during the pre-sentence investigation.
Ms. Wheeler, I believe he told you he was experiencing daily use at the time of the offense.
That's correct, until the fall of 2021. It's a bit hard to explain that in the chart because it only asks for a start date and end date, but I can try to explain that a little better in the narrative.
All right, I appreciate
We
that.
would appreciate that. Thank you, Your Honor. And the last one, on pages 33 and 34, there were statements alleged to have been made by Mr. Crumbley to a therapist on March 18th of 2024. I did speak with Mr. Crumbley regarding those alleged statements that were included in the pre-sentence investigation report, and he denies making the statements that he was experiencing sadness, depression, anxiety attacks, or any of the symptoms listed in the report. The interview was conducted by video. Your Honor, it was a video call, so there was significant difficulty in communicating, but I would ask that those statements be stricken as Mr. Crumbley indicates that they were not said. I have no further corrections after that, Your Honor.
Ms. Wheeler, any comment on that?
Judge, they are in the mental health records. I could put in a statement that Mr. Crumbley disputes this in the narrative and then explain that there were issues with communication during the video visit.
Are you satisfied with that?
I'm sorry, Your Honor?
Are you satisfied with Ms. Wheeler's suggestion?
I didn't hear the whole thing. Sorry, Mr. Crumbley was asking me a
Well, it's
question.
probably because I was coughing. Go ahead.
They are in the mental health records, but I could put a statement in there that Mr. Crumbley disputes this at the time of sentencing and then put in an explanation.
That would be great. Thank you.
Prosecutor, any comment?
No, Judge.
All right, so there are no other corrections, deletions, or additions. Is that correct?
Correct, Your Honor. There are a number of objections. I believe Ms. Smith also has some, but corrections, additions, deletions, that's it.
All right. I want to point out that each defendant has a right to and will receive an individualized sentencing in this matter. I want to confirm, because the victims impacted are the same, the court felt it would be in the best interest of the victims, the defendants, and also judicially efficient to hear all the victim impact statements at the same time. I want to be sure that neither defendant has any objection to that.
No, Your Honor, that's fine. Thank you.
No objection, Your Honor.
All right. What else about the pre-sentence investigation?
Who would you like to go first, Your Honor?
Would you like to go first?
Sure. Your Honor, we would object to the narrative summary as written by probation and also the agent's description of offense. It's very obvious that probation did not sit through trial and hear all of the evidence that came out at trial.
For sure.
There is a number of mistakes, and it is so biased that I would just make sure that ask the court to ask them to. There's so many mistakes. I mean, I could be on the record for 10 minutes going on with them, but the narrative is just not accurate. So I would ask the court to keep that in mind and make a note of that.
It's information gleaned from the police report. That's how a pre-sentence investigation is normally done. I don't think anyone here, to my knowledge, has a copy of the transcript of either trial. My understanding is ordering that is about $35,000, right?
Yeah.
I don't think anyone, the probation, of course, has not seen a trial transcript, and in any sentencing they haven't seen a trial transcript.
I do agree with you that the agent's description of offense is from the police reports and documents along those lines. However, the narrative summary of what was proven at trial, identifying 5 things against Mrs. Crumbley, is simply inaccurate. Those 5 things are pointed out in my memo. I explain each of those. If the court does not need me to make a record, I won't, but if the court does...
Well, that's up to you.
It's in the record in terms of the sentencing memo.
Okay.
I'll just give like one example. They're saying that as the 5th reason she should be considered to have committed illegal acts is because she was, let me get the right words, she was rarely home. That in itself is not a crime. That in itself is not illegal. The information put in that report is not accurate.
I agree with you. The same could be said about me.
Say me? Me too. Me too.
Okay. So I agree with you. But I guess where we're getting our wires crossed here is that Ms. Wheeler, and in every pre-sentence investigation, probation takes information from the police report. Like Ms. Wheeler didn't make it up herself, and she of course did not have the benefit of the trial transcript either. Also, the trial transcript does not include all of the information ever. by necessity of the rules of evidence, right?
I understand. The only reason I bring it to the court's attention and make the objection is because this is a document that will follow Mrs. Crumbley, and it's important that it's accurate. So I just want to make the objections for the record.
All right. All right, what else? What else from you, Ms. Smith?
Did you want me to go into the objections on the scoring and the objection on the no contact order, or would you like to first? I believe that Sister has a similar argument regarding the narrative summary and agent's description in her PSI as well.
Would you like to address that before the sentencing guidelines, or?
I can, Your Honor, if you'd like. I did submit a sentencing memorandum which does more fully outline what my objections are. However, Your Honor, in reviewing the over 14-page narrative that was provided to the court in the PSI report, it's obvious that it at least appears to myself, Your Honor, that narrative was mostly written after Jennifer Crumbley's trial. It was not written after James Crumbly's trial. It contains mostly information regarding information found in the police reports, in various witness statements, and information from the prosecutor's office, it appears. And I'm objecting to it because it is not specific to Mr. Crumbley. It's not accurate. It contains information that was not admitted at trial. It contains information that was not evidence during Mr. Crumbly's trial and shouldn't be held against him for the purposes of sentencing.
Well, I guess I agree with you. Ms. Wheeler is always very thorough, and I'm not surprised that there's a 14-page narrative. That information was taken from the police report, and I'm aware of that. I believe that the Department of Corrections always does it in that way. I don't think that there's anyone here, I could be wrong, who has read a trial transcript. I don't know, maybe someone has excerpts of it, but the trial transcript will take a very long time. The pre-sentence investigation is never based on the trial transcript. So I suppose it would be appropriate to include in the pre-sentence investigation that the narrative in the pre-sentence investigation is based on the police reports submitted in this manner, which are numerous, correct, from many different agencies.
That's correct, Your Honor.
No, Judge, just one comment as far as the PSI. This court indicated every single PSI utilizes the police report and other information to compile the narrative information.
Correct.
The court sat through the trial. The court can make the appropriate record when the sentence is handed down. The jury found these facts to be true. I dispute the characterization that the PSI is riddled with inaccuracies. I believe it to be accurate. And Ms. Wheeler obviously reviewed all the cell phone records, and those were included. Judge, you made certain rulings throughout the pendency of this trial, as you alluded to earlier. You have all the information. It's readily available to you. Nothing needs to be extracted from the summary. I have no objection to a statement in the PSI indicating that Ms. Wheeler drew information from the narrative or police reports. That's fine. Like I said, it happens in every single case. But I do dispute the characterization. But I understand the court is going to issue the sentencing individual to the offense and the offender based upon the record.
Correct. Correct. So we'll add that. We'll add that.
Thank you, Your Honor. It does, in the report, it does indicate a number of reports that Ms. Wheeler relied on in writing the narrative, and then it says, and other evidence. And again, some of the things that are listed in the narrative were not evidence in James Crumbly's trial, specifically the over 2,000 pages of text messages or messages between Mr. and Mrs. Crumbly, in addition to other messages between Mrs. Crumbly and her son and things of that nature. So I'm asking for those corrections.
We could use a different word. We could use a different word.
And Judge, again, as the court has stated, it's the same police reports that are used for each, and I do believe it's very clear in the PSI that they are conversations between Mrs. Crumbly and someone else. It certainly doesn't say Mr.
That's correct, Your Honor. I'm just ensuring Mr. Crumbly's PSI is specific to Mr. Crumbly, and that the court is considering that. That's why I'm making the objections I'm making, Your Honor.
All right, I appreciate that.
Thank you, Your Honor.
Okay, what else? Anything else about the pre-sentence investigation besides the sentencing guidelines, right?
Aside from the sentencing guidelines, the other objection relates to the no contact provision proposed between Mrs. Crumbly and Mr. Crumbly, and I'm arguing on behalf of Mrs. Crumbly, obviously, and between Mrs. Crumbly and Ethan Crumbly. This is a family. They have despite even having felonies on their records, they have a constitutional right to be a family unless the prosecution can articulate a reason that is valid and surpasses a certain standard to disrupt the family from being able to have contact with one another.
Let me give you some information that I didn't previously have. I've consulted with the probation department, the Michigan Department of Corrections. They have indicated to me that if Mr. Crumbley and the shooter are in prison, the Michigan Department of Corrections will categorize them as enemies. And I put that in quotes. The reason being that they will not, it'd be like two brothers or someone like that. They will not, they're characterized in that way, so they will not be housed in the same facility. So there is that factor. I think the other difficulty I'm having is that I got your sentencing memo at about 4:32 on Friday, and Ms. Lehman's I got over the weekend. So the prosecutor didn't have a chance to respond to that. So I'm not clear if there's. I guess I'm going to ask if there's any objection, or if you'd like to file something supplementally. I honestly never faced this issue, so I don't know.
I can just respond. My only response to this is that we're asking that these defendants be treated like any other defendant in the Michigan Department of Corrections.
Right.
And it's my information that because they are co-defendants, the no contact will be in place, and because the shooter is a related defendant, no contact will be continued. Again,
okay, you just mentioned two different issues. Because they're co-defendant, they're a man and a woman anyway, right? So they would, if they go to the Michigan Department of Corrections, they would not be in the same facility.
Correct.
Co-defendants are traditionally not housed together. There's that issue. She's asking about a no-contact order between Mr. and Mrs. and the shooter. So I don't know what your position is on that, or if you have any legal authority to support your position. If you want to respond to it later, I have frankly never faced this issue. So.
Well, yeah, that's probably true, Judge, and as the court indicated, this was objections made recently. I don't have anything ready as far as legal authority regarding that. My information is only from Michigan Department of Corrections, and the reason why they put the no contact in place, and that is because of the nature of this crime and the fact that they are related defendants. Again, we're not asking for any special treatment one way or the other. We just want whatever the Michigan Department of Corrections would do in any other case.
All right. Well, would you like to respond, Ms. Wheeler? I think you are the one who told me about the enemy status, in quotes, that would be maintained.
Yes, Judge, and there's certainly no guidebook for this situation again. Those are my thoughts on why I recommended the no contact order, but certainly the court can issue what they want. It was just my thoughts.
Would you like to respond? If not, I don't see a reason to have a no contact order at the moment. If the Michigan Department of Corrections was able to tell me the reason to have a no contact order, I would consider it. I know we haven't had a chance to respond, but at the moment, I can't think of a reason for a no contact order. If the three of them are all in the Michigan Department of Corrections, it would then be up to the Michigan Department of Corrections. But should I be ordering that right now, is what I'm asking. Is there legal authority for me to do it? The options are lifting the no contact order or allowing you to research further.
We just don't want the sentencing to be judged, Judge.
Me neither. I'm not adjourning the sentencing.
In that case, Judge, could the court hold this in abeyance so we can respond?
Yes.
That would be my preference.
All right, I'm going to do that, all right? Because I didn't really have a chance to respond to that. Just the issue of whether or not the three of them would have no contact via, I think if all three of them were in the Michigan Department of Corrections, or if one of them was somewhere else at some given time, is there allowed to be contact either by letter or phone or visit? That's what you're asking about.
Yes, that's what we're asking about.
All right.
But we, obviously, if Michigan Department of Corrections is overseeing or if they're in a facility, there's rules they have to follow, and this court doesn't order all of the rules that have to be followed.
Oh, I agree. So, that's up to the Michigan Department of Corrections.
So the court obviously will give the prosecution time to file a supplemental response. We filed our response rather quickly because we were given the PSI last week. We were given the prosecutor's memo on Wednesday, and I mean, obviously we got it. I got my report late Friday, but there wasn't much time. I would also like an opportunity to either respond to their argument or to be able to brief the issue first, if the court would like, because it's my objection, more fully than I have been able to in here.
You may.
Okay.
It's not something I've dealt with
Okay.
recently.
I guess I'm
so-
just asking what time frame the court would like, or
How long would the prosecution like to respond?
A week's fine, Judge.
Okay, so you are going to file something by April 16th, and then how would you like till the 23rd of April to respond?
that would be great. Thank you.
I mean, they might do some research and find out there's no basis for it. I don't know.
And Judge, I will look further into that and also provide the information.
All right, thank you. Thank you.
Judge, I'll communicate with the court, defense counsel information.
Thank you.
Your Honor, just for the record, I'm just placing my objection to the no contact order for the reasons stated in my sentencing memorandum. I will also file a reply brief on the 23rd.
All right, thank you. All right, what else?
Your Honor, the remainder of the objections for Mrs. Crumbley are based on guideline
All right,
scoring.
sure,
Would the court like me to?
sure.
Okay. Your Honor, Crumbley is objecting to the scoring of offense variables 7, 9, and 13, all based largely on the same reasoning. And so those offense variables are scored the way they are proposed by Michigan Department of Corrections based on the number of deaths that resulted and based on the number of persons injured. And the problem with it is that Mrs. Crumbley was found guilty of completing an act of gross negligence or failing to adhere to a legal duty, but when the shooter got the gun and made the decision to shoot multiple people, that took any and all culpability for the number of victims and put it in his hands. So the shooter, if he had gone out and shot one person, which if it's reasonably foreseeable he would hurt anyone, okay, one person might be reasonably foreseeable, the guidelines would be scored far differently. And just as a matter of course, the guidelines don't take into account a situation like this, much of the law in this case has been novel and new. So we would ask the court to score those guidelines at 0 points because...
Can you be specific about which? We need to take each guideline individually. It's important for the record, all right?
Sure. Okay, so prior record variable 7 gets scored when there are 2 or more offenses that the defendant is convicted on. Mm-hmm. And the objection in this case is that the conviction is based on there being 4 deaths. The conviction is not based on Mrs. Crumbley committing 4 acts of gross negligence. And this is a case where we have an intervening factor. We have an adult who was charged as an adult, sentenced as an adult to life without parole, who took everything out of Mrs. Crumbley's hands and made decisions himself. So to charge Mrs. Crumbley, hold it against her that there are 4 deaths, that part of it was not reasonably foreseeable to Mrs. Crumbley.
Didn't the jury disagree with that?
No, the jury found that the jury did not find 4 different ways to say that there was gross negligence. The scoring is based on the number of deaths. At the end of the day, the shooter could have gone and shot 1 person, or 4 people, or 100 people. The problem is that even if it's foreseeable that something was going to happen, when the shooter intervened and made the decision what he was going to do as an adult that was convicted and held accountable for each of those 4 deaths and everyone injured, it came out of control from Mrs. Crumbley. So we object to the scoring that she committed 4 offenses. I agree with you, the jury entered 4 convictions, but the basis of it was 4 deaths. And it's not 4 acts by Mrs. Crumbley. This is a very unusual case.
Well, if there were specifically 4 deaths intended, she would be charged with homicide, right? Isn't that true?
That would be true. But as with involuntary manslaughter, so if a person drives a car and ends up killing 6 people, there could be 6 counts, okay? But this situation is distinguishable because we have a different person who comes in as an adult, makes decisions, and takes any of what could be possible out of Mrs. Crumbly's hands.
Okay, he wasn't an adult. He was charged as an adult. Isn't there a difference?
Well, yeah, you're right. I'm saying, though, he was charged as an adult. He was held accountable for those crimes. He made the decision on how many people to shoot. He went in and made intentional choices. My point is just that Mr. Crumbley and Mrs. Crumbley, and I apologize because I'm arguing for Mrs. Crumbley, but sometimes I'll mention both. The decision on the impact of this case was absolutely not in their control. It was not foreseeable, and that's the basis of the objection. Even if we respect the jury's verdict, they found that gross negligence took place. We respect that. That's fine. We get that. But at the end of the day, Mrs. Crumbley shouldn't be sentenced as if she controlled the fact that 4 people were murdered, or if the shooter had shot 100 people. That's the objection, and this is a unique issue. It's a unique issue in that there is not case law, and it's going to be a matter of first impression.
Ms. Lehman, do you want to weigh in on this PRB 7?
I would, Your Honor. I also am objecting to this scoring at 20 points. I do believe that the proper score is for 0, for reasons similar to those that Ms. Smith stated. This is not a case where there were 4 separate grossly negligent acts alleged. It was one grossly negligent act, and quite frankly, we don't have the jury here to ask them what they found, or if they found that there were multiple grossly negligent acts. There were 4 counts for the 4 deaths of the students. And Your Honor, I understand that having these conversations, I'm not trying to be callous to anyone, Your Honor.
I know.
But the 4 counts were for the 4 deaths that occurred, not for 4 separate criminal acts on behalf of James Crumbley. I understand what the jury's verdict was. I understand that, Your Honor. However, it's not as though a similar situation, Your Honor, would be speeding through 4 different stop signs and causing 4 different motor vehicle accidents resulting in death. That would be something similar to a concurrent or a subsequent felony conviction. In this case, it is arguably one grossly negligent act that resulted in 4 deaths, and obviously also multiple injuries and other issues as well, Your Honor. But my position is that this should not be scored at, PRB 7 should not be scored at 20 points because it is one act, not multiple acts. And I don't believe that the sentencing guidelines properly consider the facts of this case. Again, we've never seen a case like this before, and I don't believe that the sentencing guidelines properly consider the facts of this case, Mr. Crumbly's case, or even Mrs. Crumbly's case, to adequately score PRB 7, and I believe it should be scored at 0.
I'm going to ask both the prosecutor and probation if you'd like to respond.
Thank you, Judge. There is 0 support for counsel's argument that PRB 7 should be scored at 0. The case law is clear, the statute is clear. There were 4 separate homicide counts. 4 children were murdered November 30th, 2021. Because of that, each defendant was charged and then convicted of a homicide count, involuntary manslaughter, each with its own elements, Judge. We've argued back and forth about was this homicide or was it not. This is why the court issued the rulings the way the court did regarding the video and other evidence regarding photographs of what happened inside the school. The statute is extremely clear. 4 separate counts. They don't get to have a scoring of 0 as if 3 children weren't killed, Judge. It is clear what the law is. It has to be scored at 20 points.
Anything further from probation?
No, Judge.
All right, well, I have reviewed this thoroughly, the sentencing memos that you have submitted, as well as the pre-sentence investigation, the statute, and the case law, and I believe PRB 7 is scored correctly with regard to both defendants.
Your Honor, the next objection that Mrs. Crumbly raises is on offense variable 9, which is the number of victims. This analysis is the same as the arguments I just made on prior record variable 7. When the shooter came in and made the decision on the number of victims, it became not a reasonably foreseeable conclusion that he would do what he did. And that is why scoring that at 100 points for multiple deaths, these guidelines don't take into account this very unique situation where a person, again, charged and convicted and sentenced as an adult, made that decision. And it violates due process and all of Mrs. Crumbly's constitutional rights to hold it against her that her son shot multiple people versus just one. So we would ask that that offense variable be scored at 0 points.
Ms. Lehman, do you want to weigh in now, or yeah?
I can, Your Honor, and that way the prosecution can respond once, Your Honor.
All right, go ahead.
OB6, again, it's scored at 10 points.
Are we talking about OB6 or OB9?
I'm on OB6.
Oh, wait.
You said OB9 number of victims.
I'm sorry.
I can do OB9, Your Honor, if you'd like, and then go back to OB6.
I went to OB9.
I can do OB9, Your Honor.
Okay, go ahead.
OB9 to PRV7, Your Honor. It was not Mr. Crumbly who pulled the trigger on the firearm that killed the 4 students, Your Honor. I'm making the same arguments. I don't think that I need to reiterate them, but I believe that it should be scored at 0.
Thank you, Judge. Regarding offense variable 9, the jury did find it was reasonably foreseeable. It's jury instructions 1615, 1618, 1610, Judge. 2 juries, 24 individuals, 24 citizens found them guilty and found this act to be reasonably foreseeable. Had they not, they couldn't have been found guilty. That's the law. Now, again, there is no justification for scoring at 0. They are homicide offenses. Each is a separate count. The statute is clear. The case law is clear. We provided supporting information and documentation in our sentencing memorandum. The scoring has to be 100 points.
Anything, Ms. Wheeler, in addition?
No, Judge, thank you.
All right, well, I agree. I've spent, even before receiving any of your sentencing memos, I spent an incredible amount of time going through all the guidelines, and I believe that OB9 is scored correctly pursuant to the pre-sentence investigation, the statute, as well as the case law in this matter. All right?
Your Honor, Mrs. Crumbly's next objection is to offense variable 6, which is the offender's intent to kill or injure another individual. We would object to the scoring of this variable because Mrs. Crumbley did not have intent to kill or injure another individual, even if she was grossly negligent and obviously found guilty of gross negligence. That does not mean she intended to kill or injure another individual. We know who intended to kill or injure another individual, and that's the shooter. He was held responsible. He was charged. He pled. He was held responsible, and we would object to the scoring of OB6.
Okay, OB6 says, or there was gross negligence amounting to an unreasonable disregard for life, right? Or.
I agree with you, but the problem is that, again, these sentencing guidelines don't take into account another person coming in and making those decisions. So that's the problem, and that's what makes all of these guidelines not exactly fit with the circumstances of this case.
You know, did you guys read, I sent you a case named Albers. Did you read that case? I thought that was interesting. 258 Mishap 578. I thought that was telling. There was a number of victims in this apartment, and someone was a fire starter, a known fire starter, injured all kinds of people there. And I think that had more to do with OB3, but I thought that was a telling case. Ms. Lehman?
The difference, Your Honor, in that case, though, is that there wasn't somebody who was charged as an adult that intervened and made the choice to hurt everyone in that apartment building. That's the difference in this case, is that Mr. and Mrs. Crumbley did what they did or didn't do, but when their son came in and made decisions, again, it took it out of their hands. And if he had made the decision to do something different with that weapon, we wouldn't be here with that scoring. That's the difference.
I don't think they were charged based on what he did with that weapon. They were charged with everything they did and didn't do up to the time that he used that weapon, right? What he did from the moment he started shooting is not really the crux.
I agree with you, and that's why the problem is that because he got involved, the offenders in this case did not have any intent on their part, and so it just makes it very distinguishable from any other case of involuntary manslaughter. It complicates it enormously, and it really does become an issue of first impression in this case.
Ms. Lehman.
Yes, Your Honor. For OB6, it's currently scored at 10 points. The defense, Mr. Crumbly, requested to be scored at 0 points. The prosecution asserted 2 separate theories during trial, which were both read to the jury. We don't know which theory the jury relied on. If they all relied on the same theory, if they all relied on different theories, if half of them relied on one and half of them relied on the other. Unfortunately, Your Honor, we don't know the answer to that. So the issue that we have is that there are 2 theories under which Mr. Crumbly could be convicted during trial. We know that he was convicted because we're here at sentencing. But neither of them takes into account the fact that there was no evidence presented that Mr. Crumbly was aware of what his son was planning. There's the guidelines, and specifically OB6 doesn't take into account that there was no evidence presented during the trial that Mr. Crumbly was not aware that his son had obtained access to any firearms in the home. And again, for these reasons, it's the intent. I understand that gross negligence is a part of the scoring, Your Honor. However, it's disregard for human life. There was no evidence presented that James Crumbly had disregard for human life. Whether it's believed he was grossly negligent or not, Your Honor, there was no evidence presented during trial. Again, notwithstanding the jury's verdict, I understand what the verdict was, Judge, but the guidelines themselves, the scoring, which is what we're doing right now, this is not retrying the case, this is just scoring the guidelines, and the guidelines themselves, Your Honor, do not take into account the specific facts of this case and the evidence that was presented during this case. So for those reasons, Your Honor, I'm asking that OB6 be scored at 0 on behalf of James Crumbly.
Prosecution.
Thank you, Judge. In Jennifer Crumbley's memo, there was no objection to OB6. We did respond and articulate the reasons why. In James Crumbly's memo, I asked the court to take that argument from our memorandum into consideration regarding Jennifer Crumbley's case as well. First, I'd like to address the counsel repeatedly calling this a case of first impression. This is a rare case. It's a unique case, but it's not a case of first impression. The legal duty in Michigan has been around for years, as has involuntary manslaughter and the law surrounding involuntary manslaughter. We actually cited Albers to the Court of Appeals as well as to this court in our response to the defendant's initial motion to quash in early 2022. That case is on point, as is People v. Cole, which is cited and attached to our sentencing memorandum. The jury instruction is clear, 1618 and 1615, Judge. OB6, 10 points are scored when there was gross negligence amounting to an unreasonable disregard for life. Compare that to our jury instructions in the case in People v. Cole, where the Court of Appeals specifically said, acting in a grossly negligent manner where it was apparent that serious injury could result implies that defendant Cole was acting with an unreasonable disregard for life. OB6 should be scored at 10 points.
Anything additional confirmation?
No, thank you, Judge.
I believe OB6 is correctly scored.
Your Honor, Mrs. Crumbly's next objection, and again, this is along the same analysis as the prior objections, is to offense variable 13, the continuing of criminal behavior. This case is scored based on there being 4 resulting murders and multiple injuries in this case. And again, this factor was ripped out of the hands of Mrs. Crumbly when the shooter decided to make a continuing pattern of behavior and resulted in multiple harms and murders. Mrs. Crumbly did not exhibit a continuing pattern of criminal behavior. There were not 4 or multiple counts of gross negligence, and therefore we would just object to it being scored at all.
Ms. Lehman.
Yes, Your Honor. For OB 13 for Mr. Crumbly, a single felonious act cannot constitute a pattern. People v. Carl, 322 Mishap 690. is a Court of Appeals case which indicated that a defendant's multiple convictions for reckless driving causing death or serious impairment arose from his single act of driving recklessly. He had passengers who were injured. There was at least one death that occurred. The Court of Appeals found that it was error to score OB 13, even though the driver of the car, who was the defendant, struck and killed someone, and passengers in the defendant's car were seriously injured. So, Your Honor, this would be something similar. This is arguably one act that resulted in 4 deaths. This is not 4 separate acts. Going back to my discussion, and I believe PRV 7, Your Honor, running 4 different stop signs. Those are 4 separate and distinct acts resulting in injuries or deaths. In this case, we don't have that. It is arguably one grossly negligent act that resulted in 4 deaths. And, Your Honor, I'm not in any way trying to minimize that those students were killed, Your Honor. But in scoring the points, it's currently scored at 25 points for the 4 deaths, and not 4 separate acts. Those 4 separate acts were committed by Mr. Crumbly's son, based on, according to the jury, his one act of gross negligence. And again, we don't know what act the jury relied on. We don't know if they believe that there were multiple. We don't know, quite frankly, Your Honor. But there aren't 4 distinct acts, 4 separate acts of gross negligence that resulted in each of the 4 deaths of the students. So again, Your Honor, for these reasons and the reasons that I stated in my memorandum, which and I do cite additional case law for the court, I believe that OB 13 should be scored at 25 points on behalf of James Crumbly.
Well, I did read the
I'm sorry, 0 points, Your Honor.
I did read the case law in your briefs, but I think there's some more recent case law provided by the prosecution in their brief. I don't know if it's Herman or Gibbs. Do you want to respond?
Yes, that's great. Thank you. First of all, OB 13 does permit the court to score 25 points when the incident occurred on one day. There was substantial evidence presented to the jury to show this was not one isolated act. Gross negligence occurred over a period of time. There was absolutely a pattern of gross negligence that culminated in the shooting on November the 30th, 2021. Just off the top of my head, buying the gun, not locking the firearm up, not taking him home when asked, not asking him about the gun on November the 30th, not reacting in a variety of different ways when shown that math worksheet on November 30th. There wasn't one single act of gross negligence. It occurred over a continuum. We presented evidence in the Jennifer Crumbley case from March 2021 till December of 2021. In the James Crumbly case, again, March from 2021 to December of 2021. Over the period of those 8 months, Judge, there were a number of acts for this court to rely upon. We do believe that OB 13 is appropriately scored at 20.
Anything else from probation? Again, I have reviewed all the PRVs and OBs and the case law and the statute, and I believe it's correctly scored.
Your Honor, the next objection Mrs. Crumbley has is to offense variable 19. This is a different type of argument than the prior argument, so I just want to let the court know. This offense variable is to be scored when a defendant interferes with or attempts to interfere with the administration of justice. And the reason this was scored against Mrs. Crumbley is because of the claim that she tried to run and tried to avoid arrest. On the night before charges were issued, I texted Ms. McDonald directly, which I attached to my memo, and said...
Judge, I know it's argument, Judge, but we've been over this before a number of times. And the court... A charged felon doesn't get to text somebody.
We've had this discussion.
And the court is already taking that, Judge. I ask you to move on.
I'm going to let her make her argument, but we've had this discussion before. Law enforcement does not have to ask for permission to arrest someone. If I have an outstanding warrant, one of these deputies could come up to this bench right now and cuff me.
I understand that, but what the prosecution has done is put together a false narrative that's been repeated by the media over and over and over. And it's been repeated in court. Ms. McDonald is the one who said they were in an industrial building. She's the one who used the word abandoned.
It was a warehouse, a non-retail place that was closed at night. Right?
It was not a warehouse. It was a building that had businesses in it.
It was a non-retail building.
No, there are retail businesses in there, and there are businesses in there that are not retail businesses. Either way, it was not an abandoned warehouse.
Okay.
Okay? And then the prosecution argued and put on the record...
I guess it's hard for me to understand why it matters whether it was abandoned or not.
Okay, because the narrative the media has played over and over and over repeats inaccurate information.
I can't control the media, trust me.
I understand. However, the prosecution also stated falsely and knowingly falsely, based on the fact they had a video of when Mrs. Crumbley and Mr. Crumbley were found, the prosecution claimed they were crouched near a mattress, which is just not true.
They were laying on a mattress.
Right. At the time, though, they made it sound like they're crouching and hiding, and the media reported that over and over and over, and that has been a major problem throughout this case, and why I asked this court for a gag order. And we were thankful for the gag order. It did eliminate some more of the narrative coming out. But the prosecution very successfully painted this picture of people on the run. Meanwhile, Ms. Lehman and I can't do anything more to get our clients turned in. We are desperately calling the prosecutor's office, filing appearances with the court, making arrangements. Our clients are being threatened so badly, they are terrified to just go walk into a jail where everyone is looking for them in Michigan. We plan to be with them as their attorneys, and it's complete garbage that the prosecution has been able to carry this narrative out through trial. And that's why I did attach my text messages to Ms. McDonald letting her know. All she had to do was say, I am charging. She did not let me know.
She does not have to do that.
It's a professional courtesy that most prosecutors do. It just is.
Not in a case like this.
Evidently.
Ms. Lehman?
Because, well, there's different arguments for each defendant.
That's correct, Your Honor. That you're different argument.
Okay.
So I just want to address this briefly, Judge. First of all, this court may recall the text messages that the court allowed to be admitted in the Jennifer Crumbley case.
At 11:16 p.m.
That's correct, Judge. Text message between Shannon Smith and the defendant. We're hiding out. We may have been found. And then the response was, oh, shit.
Judge, I object. That's not what it was.
Admissible evidence.
Right, but that was not texted by Mrs. Crumbley.
Okay, well,
she was already asleep.
Okay, here's the problem with that. Because the evidence has shown, both of the defendant's sentencing memos address the arrest in Detroit. You've suggested on numerous occasions that the prosecutor was required to make arrangements with one or both of the defendants to turn themselves in. I know that in circumstances where someone is charged with a retail fraud, something like that, you might get a common letter. They're not required to do it. Do we all want things to happen the nice way? Sure, but it's not true. Law enforcement is not required to ask permission to arrest people. The fact of the matter is the charges were announced at noon. They knew about the charges. You knew about the charges, right?
Not until after the press conference.
At noon.
And then we were trying to make arrangements.
It's my dime.
Sorry.
They do not have to make arrangements with you. I know that's the nice way. That's the safe way. The fugitive apprehension team was in contact with you. The defendants were aware and did not turn themselves in. They went to a non-retail establishment in Detroit and hunkered down. It's unclear to this court, to this day, whether they intended to flee the state. But the fact remains that they brought the circus to the city of Detroit. They did. There's also been testimony by Mrs. Crumbley and an allegation by Mr. Crumbley in the sentencing memo that the defendants were not avoiding detection in that building. That allegation flies in the face of the testimony at each of the trials. We had testimony from Luke Kirkley. He testified that he made eye contact with Mr. Crumbley in the parking lot. He went back into the building. We see that on the video at the art studio building, industrial building, whatever you want to say, that the defendant, Mr. Crumbley, followed Luke back into the building just after that. Luke immediately called 911 at 10:43. I reviewed all the testimony in this area. The Detroit police arrived 20 minutes after that 911 call. Their text from Mrs. Crumbley's phone at 11:16 p.m., despite the fact that she testified she took 4 Xanax, drank vodka, and was asleep by 11 p.m. That is simply not true. Numerous agencies, including the Detroit Police Department, Border Patrol, SWAT, the Oakland County Sheriff's Department, and the Oakland County Fugitive Apprehension Team descended on this industrial building. The Detroit SWAT team entered the building at midnight and started breaking down doors with a steel ram. They started on the second and third floor. They obtained a key to the door where the defendants were on the first floor an hour and a half later. The suggestion that the defendants were asleep and did not hear this is highly improbable.
Thank you, Judge. The only addition I have to that is the court referenced the testimony from the trial judge, and I appreciate that because retired Sergeant Hendrick, as well as Lieutenant Willis, testified very clearly upon multiple questions. It is a sheriff's office function to trigger the fugitive apprehension team. It is a law enforcement function. It doesn't happen because of a request or demand by the prosecutor's office. It's wholly separate and distinct. That was clear in the testimony. I just want that to be part of it. Thank you, Judge.
Did you want to make a different statement about that?
I did, Your Honor. And it's because I don't believe that Mr. Crumbley was assessed 15 points for OB-19 for the same reason as Mrs. Crumbley was. Mr. Crumbley was assessed 15 points it says in the guidelines, the offender used the force or the threat of force against another person or the property of another person to interfere with, attempt to interfere with, or that results in the interference with the administration of justice or the rendering of emergency services. Your Honor, I read that scoring to be scored because of the claims made by Ms. McDonald's office that Mr. Crumbley has made threats and threats of physical harm to Ms. McDonald over the phone at the jail. Your Honor, I'm disputing, and I have disputed, I did it during the trial when this was originally raised, and I've done it since then, that Mr. Crumbley has ever made a physical threat against Prosecutor McDonald. He has vented, he has been angry for the reasons that I cited in my sentencing memorandum, but he has never threatened to physically harm Ms. McDonald. He has never said that if you continue with this prosecution, I'm going to hurt you. He has never said, if you don't stop this right now, I'm coming after you. Instead, as I indicated in my sentencing memorandum, the statements made by Mr. Crumbley, although there has been some language that may not be very respectful, that may be angry out of frustration for being incarcerated and on lockdown for 23 hours a day for the last 2.5 years, for something that Mr. Crumbley and I maintain that he did not do illegally or wrong. But he vented his frustrations, Your Honor, and he never threatened harm. He never said if Ms. McDonald continues that he's going to do something, or Mr. Keese, or Mr. Williams, or anyone else at the prosecutor's office or law enforcement. So he scored 15 points, presumably based on these claims of threatened physical harm against Ms. McDonald, which we dispute ever happened. Mr. Crumbley and I maintained that OB-19 should be scored at 0. Again, we also dispute that he was ever fleeing, so even if the prosecution wanted to change their theory to the flight, we would dispute that he was even fleeing, although I understand what the court just indicated and what Mr. Keese has indicated previously. So for the purposes of scoring, OB-19 should be scored at 0. There have been no threats of physical harm. There have been no interference with the administration of justice.
There is a thumb drive of the threats. We could play them, or Mr. Keese could read them into the record. I don't know to what extent the prosecution would like to address.
I do. I hope not to, Judge, but I do need a response in here. I'm not going to read all of them. They're on page 4 of our sentencing memorandum. And we did attach them as the court indicated. So I know the court has listened. OB-19 should be scored at 50 points if the offender used force or the threat of force against a person to interfere with or attempt to interfere with the administration of justice. I don't know any other purpose for what James Crumbley did other than to interfere with the administration of justice. He knew specifically that his jail calls were recorded. He knew, or at least he believed, that the elected official, Ms. McDonald, was listening to him because he sent a message specific to her. He did it not just in an abstract sense, Judge. He did it while she was actively prosecuting the case. I have had a number of instances where defendants threatened witnesses. Rarely do we see a defendant threatening the prosecutor, let alone a member of a trial team, let alone the elected official. There will be retribution. She's going to be fucking sucking on a fucking hot rock down in hell soon. I am fucking on a rampage, Karen. Yes, Karen McDonald, your ass is going down, and you better be fucking scared. I didn't want to read that, Judge. That was just a few weeks before the trial. I don't know any other definition what that could be other than a specific threat made to a member of the trial team. We ask that this defendant be treated no differently than any other defendant who would make a similar statement to any prosecutor or defense attorney or judge in this building. OB-19 is certainly scored at 15 points.
I believe that it's correctly scored with regard to Mrs. Crumbley and Mr. Crumbley based on their avoiding law enforcement while at the art studio, industrial building, whatever you want to call it, on that evening for a long period of time. But in the alternative, there's alternative theories for scoring OB-19 with regard to Mr. Crumbley. Regardless of his ability to make good on those threats because of his incarceration, I still do believe that those were threats against the prosecutor.
Thank you, Judge.
Your Honor, Mrs. Crumbley has no further objections to the scoring at this time.
Ms. Lehman.
Mr. Crumbley has no additional objections to the scoring, Your Honor.
All right. I have a number of written statements that were provided by various individuals. I'm going to read the names of the people. Could you tell me the pronunciation of Hanas and Baldwin's mother's name, Nicole Osolea?
Yes.
Osolea. And the mother of Hannah, Ms. St. Juliana, is it I, St. Juliana, Kristen Baldwin, Raina St. Juliana, Steve St. Juliana, Jill Scabe, Molly Darnell, Danielle Kozak, Andrew Muska, Marla Lay, Olivia Upham, Renee Upham, Megan Gregory, Patricia Cunningham, Linda Russo. Those are individuals who provided written statements, and I have copies of those. I wasn't sure who had what statements, so they were scanned by my office and sent to everyone yesterday. I know that there are a number of individuals who want to address the court. I guess I should ask if at any time anybody feels like they need a break, they should tell me. All right? All right, so you have not objected, correct?
Yes.
All right.
Correct.
Do you want to do that at this time?
Could we take a break now?
Yeah,
before the impact statement.
Yeah, do you need a break? Oh, I guess I would ask, you've had time to review the written statements, correct?
Your Honor, we did get them late last night. I'm going to read over them during this brief break again. I have read over them once, but I'm going to read again just to ensure that there are no objections.
Yeah, I didn't have reason to believe that you didn't have copies of them, but they weren't necessarily funneled to the probation department. Some of them were sent directly to us. I've gotten letters from people from across the country that were very interesting. So,
Your Honor, may I say one thing regarding the victim impact statements? The victims are not in the courtroom required to provide their oral statement to us before they deliver it.
Correct.
And some chose to do that.
Correct.
Some chose not to, based on our prior experience with the shooter sentencing. Sometimes they chose to submit it, and it was different when they delivered it. So I just want to make it clear that we, under the Crime Victim Rights Act, nor do I think it's appropriate, have any control or edit or of what they're going to say, because it's their impact statement. So.
Yeah, I understand, and I have gotten some written statements from individuals who I believe intend to make an oral statement as well. So, yeah, that's up to the individual. All right.
Your Honor, with respect to the statements, initially, the defense for Mrs. Crumbley was concerned about the number of statements. We believe that the court can sort through what to take into consideration for this sentencing, and plus the court has lots of experience doing so. And so we do, if at some point there was an objection in terms of discussion, we don't have an objection at this time.
Yeah, you know what? You guys were on this email yesterday that discussed all of the individuals who would be giving oral statements.
Correct, Your Honor.
Yes.
And I know we all went back. I think we've all discovered a little glitch in the Crime Victims' Rights Act that it's not specifically clear who's considered a victim under the Crime Victims' Rights Act. There's some difference of opinion maybe, but I'm again relying on Albers that discusses OB3 and gives a broad definition of who a victim is. In any event, I am inclined to hear oral statements from all the individuals that were listed in the email that went to all of you last night. All right?
I have no objection to the individuals on that list, Your Honor.
All right.
Yeah, same here.
And I certainly would appreciate you making any objections to their statements at the end of their statement, right?
Your Honor, I don't know if we need to approach on that, because there was some discussion by email about the objections.
Okay, well...
or maybe we can handle it during the break, Judge.
All right. When you say making an objection while the individual... I'm going to insist that everyone keep their statements directed at sentencing, for sure. Okay?
Your Honor, I don't anticipate, and I don't believe Ms. Smith would anticipate making objections to a victim impact statement. Obviously, things could have, Your Honor.
Excuse me.
And obviously, we have duties to our clients as well. We wouldn't be doing it in a disrespectful way to anyone, Your Honor. But we would just ask, again, you've already reminded the court. I'm certain that the prosecutor's office has reminded anyone making a statement what the guidelines are in relation to those statements. So I don't anticipate having to make an objection, Your Honor. But obviously, if one arises, an objection would have to be made, Judge.
All right. Do your clients need to go downstairs?
Yes.
Yes, Your Honor.
Just two things briefly. There are no guidelines in the victim impact statement. It's how the victim's impacted. It's personal and unique, Judge.
Sure.
Obviously the court knows that. I just wanted to make sure we were clear on that.
But they have to be directed at sentencing, the statements.
In one housekeeping matter, we just need to add in, we could stipulate, with the defense would stipulate, we add in the additional victim impact statements received last night, as well as James Crumbly's GED verification, just for the PSI.
Oh, I didn't ask you if you had any additions to the PSI.
That's all.
Did I? I'm sorry. Okay. His GED, and what else did you say?
His GED verification and the additional victim impact statements that weren't received by the department.
Yeah, I think we got some at about 6 o'clock last night, right? So, yeah. If you're not in receipt of something, you should let me know. It was hard to determine at one time who was receiving what. So
If maybe we can discuss with the prosecution who we should have impact statements from and determine whether or not we are missing any impact statements, the written impact statements, because we did receive some later last night. I don't know if...
Yeah, we sent those last night.
I received what the court sent and what's in the PSIR.
Correct. That's what I received as well.
I don't think there's anything else.
We received one this morning.
From Mr. Schilling.
Yes, sir.
But I believe Mr. Schilling is going to make an oral statement.
Correct.
Is that correct?
Yes,
So
sir.
I wasn't concerned about that.
Thank you.
I was referring to the written letters received by the court.
Okay.
That's what we got last night.
Night.
Correct, Your Honor? Okay.
Everything in my possession was sent.
Thank you very much for clarifying, Judge.
All right. All right. So both of the defendants are going to go downstairs. So I want everyone to remain seated during that. All right. Thank you.
You're watching our special coverage of the Crumbleys sentencing. As we see, court is going on break. We're going on a short break here on the stream as well. We'll be back in just a few moments. Welcome back to CBS News Detroit as we cover the sentencing of Jennifer and James Crumbley. We now want to bring in our legal experts who have been with us from the very beginning, attorneys Lillian Diallo and Rick Convertino. Thank you so much for being here. So we know court is in a brief break. So there are some things I want to dig into. Let's start with James, Rick. Some of this communication they were mentioning, threatening messages perhaps to Karen McDonald. What was said? Because until now, I didn't know what was said. But it's much nastier than one realizes.
It is. There were 7 recorded calls from the Oakland County Jail to a unidentified third party, all of which were recorded. There's a preamble on all calls that are coming out of any jail or prison, which notifies the recipient of the call that the call is being recorded, and so there's notification right up front. James didn't seem to care, as he let the listener know that his rants about and threats to and about Karen McDonald, the elected prosecutor and lead prosecutor in this case, were all on the record and of course reviewed by the Oakland County Sheriff's Department, and it's submitted in the pre-sentencing memorandum as an aggravating circumstance to upwardly depart from the guidelines. Among the calls are James's manifestation that you effing Karen McDonald, you're an effing stupid bitch. I hope you're listening to this, you effing bitch. He then goes on to say over and over how stupid she is, how he's going to take her down. These are on separate calls, so he repeats his threats on 7 different occasions. There will be retribution, believe me. He said that on December 23rd. He said on December 6th, yeah, you effing Karen McDonald, you're effed when I get out. He's saying that you'll be down in hell soon. He later tells her that he's on a rampage. I'm excluding the expletives here. He says, your ass is down and you better be effing scared. So he repeats these very caustic threats on numerous occasions, knowing ostensibly that they're recorded. He says, I hope you're listening to this on one occasion. Those are, I said earlier, you know, he has a constitutional right to be stupid, but these of course are going to be used as aggravating circumstances to enhance the sentencing. Later on, the prosecution uses the threats. They were brought up in court. After the threats were brought up in court, there were no more threats that emanated because the prosecution asked for an order that limited his communication directly to his attorney only. So there were no more threats. But on March 7th, the prosecution alleges in its memorandum that the court revoked the defendant's communication privileges during trial in an order on March 7th, after which he could no longer express his threats to jail calls because his privileges were revoked. He chose to gesture the middle finger toward the prosecution of the trial and says that, and there's the exhibit 9 in the sentencing memorandum. There are other pictures in the sentencing memorandum which show the same thing on various occasions. So the prosecution alleges that that's an outward gesture of protest directly to the prosecution. Now, as a former federal prosecutor, I've had defendants that have done that to me in court.
Really?
Yeah, I've had that happen in court. One time I had a defendant who we tried to work out a plea deal. I made an offer to the defense attorney on the eve of trial. The defendant leaned back around his defense attorney's back and flipped me off. So we went to trial. He was convicted, and he got and I brought that up, and that was a part of the upward departure for the sentencing. So you know, it's ridiculous. Whether or not he's doing that, that's you know, that's for the individual to assess. But it seems as though that was a clear manifestation of his distaste and disdain for the prosecution in this case. So
this could affect his sentencing, you think?
Well, they're asking for
make
it.
A heavier sentence for him?
They're asking for it to enhance his sentencing. He also does something that, you know, I'm sure Lillian will agree, she said it earlier, that there is absolutely no remorse by either defendant in this case. It's replete in both the prosecution sentencing memorandum and the defense sentencing memorandum. The prosecution, in the pre-sentence investigative report, the defendants are allowed to give a statement, a written statement. And in James's written statement, he says, you know, my son did this shooting. He says, I am wrongfully accused and now wrongfully convicted of involuntary manslaughter. I followed the law and took gun safety to the very extreme. So this is a defendant who comes before the court without remorse, without recognition of his guilt. And this is all for the judge to view and assess when she decides whether or not to mitigate or to aggravate his sentencing, or whether to depart upward or downward from the sentencing guidelines. So I think it's pretty clear, based on all the information provided for the court, to the court, and the way that the court has ruled this morning on some of the offense variances, variables that were argued before her, that she ruled in favor of the prosecution, and she was prepared and read some of the basis upon which she sided with the prosecution. So I just think that it's going to be a bad day for the defendants all around.
You know, this paints a very different picture of James than we thought throughout his trial. We know he did not take the stand in his trial. We felt that the defense painted a pretty good picture of who he was, maybe not the best father, but as she says, not guilty of involuntary manslaughter. So Lillian, when the defense attorney stands up and says, these were not threats, this was a rant, is there a way to even defend this?
That's pretty bad, what he's saying, right? Because he knows what he's saying. He knows who he's saying it to. That's pretty awful, right? But if there's something else that can happen from this, charge him, right? Don't, you know, he's just, maybe he'll get some mental health treatment, because that seems to be something that is definitely needed. I don't even know how you wrap your mind around everything and then say you're the victim, right? No, you didn't do everything. So behavioral treatment all around, I think, for him. As far as flipping the finger, what he's doing and what's pictured versus what happened to Rick, I think is different. Because we saw in this trial, one of the defense attorneys was fixing her eye makeup or saying something, and there were two middle fingers.
Shannon Smith.
Well, I'm not going to call names.
Oh, well, I just did.
It's not nice, but in any event, right. So, you know, you can, I guess, do that and say it was an innocent thing. That's different than what happened to Rick. You know, I've had people say things, but so, right, I got a tough skin. I'm a criminal defense attorney, so, so it happens. I think they need to be judged by this conduct, but those jail calls are special to me, because what it shows is he is kind of full of rage, right? And it's not rational rage. It's rage at Karen McDonald, a female. You had a male prosecutor. You didn't say not one word about Mr. Keats, right? So that makes me go, something is amiss in the house of Crumbleys. And they need to fix that, because as a country, we cannot sustain and keep sustaining this same level of acrimony, charged words, things of that nature. Stand by your word, stand on what you stand on. If you're saying something, say it, but you're wrong for saying it. And my sympathy, I have way more sympathy for him before this.
Right. Yeah, it was a very, very different image portrayed. Once we see these messages, it's pretty shocking. Now, Rick, take us through. There's been a lot of objections so far. We haven't even gotten to the victim impact statements yet. We're approaching 11 a.m. So there's been some back and forth regarding visitation. It sounds like within the system. It sounded like the prosecution moved to not allow these family members to have contact. They were classified as enemies. Just break down that interaction. Well,
the determination that the defendants would be classified as enemies is a legal one. It's not. And the judge pointed that out. It doesn't mean that they're actually enemies in the common parlance. but enemies for the purposes of the Department of Corrections. So there will be no contact. There'll be no. They'll not be placed in the same institution. So remember, they're in the Oakland County Jail, which is the local jail. And each county has a jail, and they will be removed, I would anticipate, within a week when they're sentenced, and they'll be placed in their state institution, which is a prison. So a jail is typically where someone is held for an offense of a year or less, or if they're awaiting trial. And a prison is somewhere where somebody is placed to determine their sentence, to serve out their sentence. And there are some pretty rough prisons in the state of Michigan. So they're not going into a minimum security, I would anticipate. They're going to be probably in a medium, would you say, medium penitentiary?
There's only one for women in Michigan, and so from what I understand, the conditions there are deplorable. So it's not going to be easy.
No. Do you know where that is?
Huron Valley.
Oh, okay. So that's not far.
No, it's not. It's in Ypsilanti.
And we know the shooter is in the Thumb Correctional Facility. Is that the nickname for it, or is that the official name?
It's a nickname.
It's a nickname. And we know that he got into a physical altercation with another inmate. Did you hear about that?
Already?
Yeah,
yes.
he did.
Yes, maybe a couple weeks ago. We don't know what was said, but yes, he got into a fight. Just shows those conditions, and also how charged this case is. We heard from Shannon Smith. She mentioned it was difficult for their clients to walk into jail.
It's difficult for any client to walk into a jail. Your client is no different, right? And I've had high-profile cases before. So they take different precautions. So in one instance, you have a better advantage because they're going to try to keep you in segregation. But let's talk about some of these objections that we were listening to. Like on one of the OVs, I think the strongest argument is this, OV6. It's to be scored when it's a crime against a person only if the sentencing offense is homicide, attempted homicide, conspiracy or solicitation to commit a homicide, or for the offenses committed after October 1, 2020, assault with intent to murder. So my argument would be that doesn't get scored at all because this is involuntary. That's your argument. You know, about the 4 separate people and, it was one event. Well, the jury convicted them of 4 things. So if you're convicted of 4 things, in the prior record variable number 7, they only score for 2 at the most, right? You're convicted of 4. Even though it is something, maybe the law will change. Maybe the legislature will change something. But unless and until it does, you make your objection and you move on, but you don't miss the things that are low-hanging fruit. Low-hanging fruit is homicide. You're not convicted of homicide.
Can you explain, you're saying score, and can you explain for viewers what score means?
Right,
Okay.
but how sentencing is working.
Right, in Michigan, everything is, by scoring, until there was a case that came along that said they're just advisory guidelines, right? That means you don't have to follow them, Judge. You can go under them or you can go over them, but you have to give a compelling reason. You have to state a reason to do either one, to go under or to go over, right? So in Michigan, you use the prior record, what the person has. So they didn't have much of anything, but the problem with their prior record was that they got more than 2 convictions. So that makes you already a 20. So that bumps your guidelines up, right? Instead of you being at a 0 and an A, you're going to be at a 20 and a C. It sounds more complicated than it is, but I never thought I would know this stuff like this, but I do.
This is to help the judge.
Right, it's just to help the
down.
judge. Understanding the prior record. Who is this person? Individualized sentencing, right? And then the offense variable. 4 people are dead. So there's a scoring for that. So we need to find out, okay, where we are. Are we going to stay in the guidelines, or are we going to go over or under? James makes a heck of a argument for over because he's just wild. He's out there, he's just being reckless with his mouth. But really, if I was the defense attorney, I would argue, yeah, it wasn't a good thing, it wasn't a great thing, it was awful, right? But it should not be used and held against him in this case. If you want to do something, charge him with another crime, right? But he was just ranting. He had no effect on, really, he couldn't get to Karen McDonald immediately, right? Although it's repugnant, right, that you would pick on the female out of the group. But, you know, that speaks to who you are, not who I am. But in any event, I think it's going to hurt him, right?
Yeah.
I'm just trying to argue from the defense perspective. It has to hurt him. You can't have that kind of stacked commentary.
Rick, do you think then in this case there will be different sentencing between Mr. and Mrs. Crumbley?
That's an excellent question. You know, you have four different, as Lillian, you know, brilliantly just laid out the guidelines and how they work. You have four separate interpretations of the guidelines in this case. You have the pre-sentence investigative report, which also has a guideline recommendation. You have both defendants, 1 and 2, who have guideline recommendations, and you have the prosecution, who also has a guideline recommendation, and they vary. Each one varies. You have one defense attorney who's saying, you know, hey, let her come live in my, you know, backyard. You have another defense attorney who's asking for a period of time between 28 and 43 months, and you have the prosecution who's asking for upward departure of a time between 10 and 15 years. So huge variance. I think that my guess is that both sentences will be the same. James may get an additional time, but you know, as Lillian will tell you, she just said it's terrible for any defendant to walk into any form of incarceration. But here you have, you know, you have to look at, you have to take a sentence for your client who's been convicted in a very sterile, objective way. You know, the ability to score guidelines, as Lillian said, in a manner that says, you know, this is an awful, awful case. It's deplorable circumstances, horrendous effects, but we have to look at this, you know, in a very sterile way. Go from OV to OV to OV.
What's an OV?
Offense variable. And you argue it, you know, systematically. And the thing that's surprising here, and actually the judge said it's never happened since she's been on the bench, is the late period of time in which these sentencing memorandums were presented to the court. They're lengthy, they're involved, not the prosecution, that was timely, but the defense presented their sentencing memorandum just a few days ago, not giving the court much time to contemplate and do independent research based upon the objections of the defense attorneys.
And this was a feature in Jennifer Crumbley's trial.
Yes.
We saw Shannon Smith submitting things late, asking questions last minute about evidence she's never seen.
Yes.
I mean, in the day of, you know, we're ready to go, we're ready to begin the testimony, and she's bringing these objections, and she's doing this again.
Yeah, honestly, in this case, I'm kind of loath to say it, but Jennifer Crumbley would have been much better served had she had a different attorney do the sentencing for her.
Do the sentencing for
Yes.
her? So you can split attorneys?
Yes.
From trial to sentencing?
Yes. Yeah.
Interesting. Do you think she stuck with her perhaps because she believes she might be able to stay at her house?
I don't think any objective, reasonable person beyond all peradventure would believe that a judge, after these facts in this trial, would allow defendant Jennifer Crumbley to live in the backyard of Shannon Smith. Now, even the prosecution says it's a slap in the face to the evidence and the families and the victims. They submit outrage in their prosecution memorandum regarding that that request. They confirmed it with Shannon Smith before they presented their sentencing memorandum that she had, you know, wanted the defendant to live in her backyard. And I just don't, I think it's wholly indefensible, and I think it's, you know, to overuse an overused lawyer term, it is, in this case, it's applicable, it is outrageous.
Mm-hmm. And we're seeing the courtroom, they're waiting for the defendants to come back in the room after this break. So Lillian, just set the tone for us. I believe it appears they've sort of finished these objections and back and forths, and now we're ready for victim impact statements. Prepare us for those. Prepare our viewers for those.
So what's going to happen is they'll ask, whoever, one at a time, to talk about what this crime did to them, what impact, and as you heard the judge say, direct the comments to the court and not the person. Because we've had sentences where sometimes people get out of control and they'll start cussing at the person and talking about, well, look at me. That's not appropriate. The appropriate thing is talk to the court about this impact so that I can fashion a sentence based on everything, right? It's going to be past emotional. There's not a word that I can come up with that's going to try to prepare anybody for this. I've sat in these sentencings. I've sat in sentencings that have nothing to do with me, that I shed some tears on, right? Because it's the loss of life. Who has the right? Yeah, everybody has a role in the system. You don't have the right to take something that you didn't put out here, right? You don't have the right to take that from this earth. And I really mean that. You have to defend certain things, right? You don't defend that behavior. Those people should not be dead. So those are the things that we are going to look at. It's going to be so incredibly difficult. It's not just for us watching it, for them. Because they don't want to be there. They're not looking for 10 minutes of fame. And as we heard one defense attorney, she kept saying, media, media, media. The media did not put a gun in that boy's hand and fire at those 4 people. This trial was this trial. You have to look past the media and worry about the facts. You should not just be disagreeable just to be disagreeable. And we were seeing a little bit of that today. And the guest house thing, I think you said something that made me go, Eureka. Maybe that was, and Rick, maybe that was a moment in time to placate the person so she did not flip attorneys and go, okay, this is enough. She's really in my corner. I'm not saying she isn't, but there were some things that occurred that caused people some pause, right? I'm not against Shannon. I don't dislike her. Personally, she's a wonderful person. That's not what we're talking about. This is a job. Everybody has a job to do, and you do it to the best of your ability. You don't make it about you. You don't make it about them. You make it about what are these facts, right? And that's that. Leave it alone.
And the key job of any defense attorney, and any prosecutor for that matter, is to represent your client in a zealous, vigorous manner, and not inject yourself into a case. But you need to be cognizant all the time that any step you take should be in the very best interest of your client. And one of the things that's going to happen here, of course, we talked about it earlier, is the next step is the appeal, the criminal appeal, which is a constitutional right of any defendant to appeal this case, and they will. One of the things that's critically important is I think, to have an independent attorney or a new attorney come in for the appeal. Because one of the things that will be challenged here is ineffective assistance of counsel, and neither one of these attorneys are going to say or claim as an appellate issue that they were in fact ineffective. And so that would take that issue off the table if the same attorneys are representing the clients in the appeal.
Interesting. And before we went to break, Judge Cheryl Matthews spelled out very clearly to both defense attorneys there shall be no objections during these victim impact statements. It sounds to me perhaps a message directly to one of those defense attorneys who does have a habit for objecting quite a lot. How taboo is it to? Does anyone ever object during a victim impact statement?
The only time that I would think that would be appropriate is if you're directing everything at me, and I'm not objecting. I'm like, well, excuse me, Judge, could you have them direct their comments to the court? You can't object. What are you objecting to? I mean, these are their emotions, right? Only thing, I would pray that would not happen. I have never seen that done, where you object. And I've been in a lot of courtrooms, right? I just don't think it's in par with us as human beings. Forget defense attorney, prosecutor, judge. As a human being, let them express whatever it is they have to express, as long as it's expressed correctly to the court. They may say something about you. That's okay. We got thick skin. Suck it up.
And she said to save any comments, any objections until after the statement is made. So is that common? If you do have an objection, to say what you will after a
Well,
victim impact statement?
James's attorney indicated that through a series of emails that occurred last night when they were notified of the witnesses who would testify today, that she had some objections. And you may recall she asked the court, can we approach and deal with that now? And the judge said after the break, or we'll deal with it in the break. So they may have done that now. Yeah, it's extraordinarily bad form to interrupt, certainly a grieving person who's, pouring their heart out to the court, object for some technical issue or some legal issue. And so the court asked that both attorneys address those on the record at an appropriate time after the testimony has been presented to the court.
Mm-hmm. And both defense attorneys did say that they do not have any objections to who is speaking, correct? You receive a list of all the victim impact statements that are going to be read.
So sometimes you do, sometimes you don't. As long as they fall up under the Crime Victims' Rights Act, right, they can give a statement, right? So they don't have to submit something in advance. They can if they want to, right? So if I'm not a direct victim, even though we feel like we were victimized in all of this, because as a community, we remember the day, we remember where we were as this was all unfolding, right? I don't have the right to give a victim impact statement. Now, if the attorney says, come on, anybody that wants to talk in America, you can come, well, that's on them. But normally, that's not how it's done.
And Cheryl Matthews said something interesting before the break as well. She said, she was reading up on the law, and it is a little gray area in this case as to what constitutes a victim. So many people could be considered victims of this crime.
Yeah, there's an attenuation, as Lily was just saying, between victim pursuant to the statute and a victim in general. And so the court has narrowed it down to include the people who are who were directly impacted by this.
And how many people are expected to speak? Do we know?
I'm not sure, but you can't, I don't know. I wouldn't think this judge would limit that in a case like this, because we know we have 4 dead people and the attempted murder people as well, but they're not charged for that. But they're going to say there was an impact, a direct impact to me. So we'll see, what happens, but I know for certain the family of the 4, they get to speak.
Well, it's 4 minutes to 11 a.m., and if my memory serves me correctly, the shooter sentencing took 2 days. It happened across 2 days. Do you think that could happen with this case, Rick, since we're getting a bit of a later start?
I don't think so. I think it'll be done today, as just a guess. I think it'll be done today. I think that there, the effort to prolong this, I don't think anybody has a desire to do that. As Lillian said, the court, I think is loath to cut off anybody from appearing before her and giving the impact statement to the court. It's important for the court to hear that. And remember, as Lillian said, one of the greatest impacts that this will have is the person who's directly in front of the witness, who's listening directly to the testimony that's being spoken to her, and that is the judge. And one of the things that we learned in law school right away is judges put their pants on one leg at a time, just like you and me. So the effect will be profound.
All right, well, we see the court is resuming now. Let's take a listen back in, but we do want to remind our viewers that some things you see and hear may be disturbing.
Judge, only the sentencing guideline manual states that you cannot aggregate victims of separate crimes, but I think the defense argued earlier that this wasn't a separate crime. And the shooting occurred in a span of 8 minutes. It was not one shooting and then a half hour later. It was a very quick effect.
Excuse me, I'm sorry. Again, I believe it's correctly scored.
Thank you for allowing me to make the record.
Sure, no problem. All right, and then with regard to victim impact statements. Sure.
Good morning.
I was doing a great job at the French pronunciation of your name. Correct?
Correct.
Was that right?
Yes.
All right. What do you have to say?
I would like to start with the person that matters the most. Madison, she was a kind soul. She always had a smile on her face. She lit up the room when she walked in. Her laugh I could listen to all day. It was infectious. Her big sister skills were undeniable, and she took that role very seriously. Madison was smart, funny, loving, passionate, determined, and genuine. Her expectations were high, and at times we needed to let her fall. She needed to be reminded that not everything is perfect, even if she wanted it to be. Madison had an influence that most never achieved. Sometimes I would listen to a poem she wrote or watched her create art with no tracing, just pure talent. She would talk about college and what majors she would like to do and what would be most helpful to society. The passion that she had for everything and everyone was remarkable. I would catch myself watching her and thinking to myself, how lucky am I? I'm the one that gets to be her mom. What did I do to deserve a perfect person? She will be the best thing to ever happen to me at such a young age myself. I grew up because of her. We grew together. I learned from her. I mattered because of her. From the moment she was born, I promised myself that I would be there no matter what. Through the falls, heartbreak, letdowns, and struggles, I would be there. I would listen, learn, and love every moment. I wouldn't miss a thing. I would always protect her. On November 30th, 2021, exactly 17 years, 6 months, and 13 days made me break my first promise, and it will hurt for eternity. As her mom, I didn't protect her. First, I'd like to say thank you to the prosecution team. I say thank you to you all. Saying thank you really doesn't seem enough anymore. The countless hours you've worked, the time away from your family, and always taking our feelings into consideration. Karen and Mark, the work you've put into getting all the facts, speaking to us like we matter, and never wavering from your goal. It speaks volumes of the people you are, and I'm proud to call you a part of Madison's voice. Advocates and Jen, I'm not sure where to start. You've all seen me hit points in this tragedy that some days I wasn't sure who it was. One minute I'm laughing, next I'm crying, and sometimes I'm just silent. Either way, one thing stayed consistent. You always listened. Jen, you're not just a friend, you are family. My mind keeps going back to something during the trials. Something that is almost on repeat like a broken record. It's something as a mother I can't understand, and honestly I don't think any mother would understand. It was when Jennifer said it wouldn't do anything different. I'm putting a little emphasis on different, as I know life throws us things that are out of our control. But life takes turns and eventually puts them back in our control. Like giving you a hint when something needs to change. I want to compare a few things to see through my perspective. As I know things are different about the events and how we see them from the events on November 30th. While your son was hearing voices and asking for help, I was helping Madison pick out her senior classes. While you were purchasing a gun for your son and leaving it unlocked, I was helping her finish her college essays. While you dropped him off at school, upset that he was failing class, I texted Madison, drive safe, it's slick outside, have a good day. When you got a call to me at the school about your son and how it interfered with your day, I was rearranging my schedule so I could take Madison to get her oil changed for the first time. When you left without hesitation and not taking him home, I was worried if she'd be okay driving in the first snowfall of the season and if she brought a coat. When you walked out of the office with a steady pace after hearing an active shooter, I ran from my home and started driving, trying not to break the law. When you were on the phone for 10 minutes with each other trying to figure out where the gun was, I was on the phone with her father and family trying to figure out where she was. When you left the Myers without knowing where your son was, I was desperately trying to get there as soon as possible. When you knew the gun was missing, you called the police, knowing it was your son who took it. I was having family call every hospital describing what she looked like. When you texted, "Ethan, don't do it," I was texting Madison, "I love you, please call Mom." When you found out about the lives your son took that day, I was still waiting for my daughter in a parking lot. When you questioned the reasoning on why you would do this, I was questioning if I was doing enough to find her. When you got a chance to speak with your son, seeing him alive and showing no support, I was watching families reunite with their children, waiting for my moment. When you asked him why, I was waiting for the answer onto why the last bus never came. When the police showed up at your house, you didn't understand why they were there. And I was asking police if they checked every possible location and if I could go search too. When you texted about not losing your job and you needed a lawyer, I was still calling my daughter because she came first in all parts of my life. When you could leave your house, I was still a prisoner in Myers. When you worried about what people thought of you and feeling threatened, I was learning your son threatened my daughter and fatally shot her in the head. When you drove to get your burner phones for communication, I was laying on the floor in Myers for hours crying because I forgot how to speak. When you checked into your first hotel, I was telling Madison's 11-year-old sister she was gone. When you cared more about yourself and getting alcohol and supplies, I was identifying my daughter in a medical office wishing I could take her place. While you were hiding, I was planning her funeral. And while you were running away from your son and your responsibilities, I was forced to do the worst possible thing a parent could do. I was forced to say goodbye to my Madison. We all see things different. Some prioritize and some don't. Accountability can only be given if you actually tried in the first place. As a parent, we all make mistakes. This is a normal way of life. Usually when mistakes happen, we learn from them. We try to fix it or talk it over. But continuing to make the same mistake over and over again is no longer a mistake, it's a choice. That becomes a decision. Those decisions that you made ultimately took my daughter's life. Because you decided that you didn't want to parent and listen to your son. You took the right away for me to be a mother. You do not get to decide that. You do not get those privileges. You are not above anyone. I love being a mom. It's the one thing that I'm truly great at. You cared more about your well-being than the one life that you should put above anyone, your child. And because of that, you both took 4 beautiful children away from this world. Being a parent is the part of life that you should hold to the highest level. It's an honor to be a mother or a father. Even when you think you have done your best, you continue to do more. Unfortunately, you never made it to level 1. You say you wouldn't do anything different. Well, that really says on what type of parents you are, because there's a lot of things I would do different. But the one thing I would have wanted to be different was to take that bullet that day so she could continue to live the life she deserved. You show no remorse, no respect or compassion for our family. The same traits that you've bestowed upon your son. The traits that you have torn my family into pieces. The lack of compassion that you have shown is outright disgusting. Not only did your son kill my daughter, but you both did as well. The words involuntary should not be a part of your offense. Everything you did that day, months prior, and days after were voluntary acts of your son to commit a murder. Not just one, but multiple. Shaking your head during a verdict is the utmost disrespectful thing I have ever witnessed. At that moment, you felt your life was more valuable than my daughter's. I will say that will never be true. You created a life that you took for granted. You decided that parenting wasn't a priority. Putting your child first should be the only priority. You didn't, and because of that, I've lost my daughter. I had to get answers after her death. Watching the video, hearing testimony on how your son executed my daughter, watching him put the gun to her head as she covered her head and pulled the trigger, seeing pictures of her laying in her own pool of blood, knowing her body sat there for hours, that rigor mortis had already started to set in, so that when I identified her, her body was in a state I couldn't imagine. Hearing her sister scream over and over again night after night, watching her family and her friends fall apart. You created all of this. You created your son's life, which then allowed this to be his path, which should be yours as well. You don't get to look away. You don't get to cry. I didn't get that choice. You failed as parents. The punishment that you face will never be enough. It will never bring her back. It will never be a loss that you have suffered, and it will never heal the pain. Because one day you're going to be able to see your son, visit, hear his voice, possibly laugh, maybe see him grow. I will never see that again. The so-called loss that you say you have suffered doesn't even compare to the loss of a child. Your Honor, I request that the maximum sentence be enforced, as it will never come close to the life sentence I was given. A life sentence that I didn't ask for, but a choice that was made for me. A life that I will suffer because of their negligence. Thank you.
Thank you for being here. Good morning. Can you tell me your name?
Yes, Jill Swatter.
All right, go ahead.
Yes. Thank you, Honorable Judge Cheryl Matthews, for your time on this case. I know it hasn't been easy on both. Thank you also to Karen McDonald and the entire prosecution team. We appreciate your efforts. Your Honor, my trauma and devastation is hard to put to words, but I have done so in my letter to you. I would also like to mention Justin's brothers, Nathan and Clay. They are now forced to live a life without their beloved middle brother, Justin. My son Justin was the least deserving of his fate. He was the best son that any mother could pray for. Justin was brave, spending his final moments protecting a fellow student. He was hardworking, a lettered athlete, a top honor student. He was kind and inclusive to all. He was full of love and joy. His future was so very bright and full of possibilities. His passing has touched so many family members, friends, students, and the community in general. The ripple effects of both James and Jennifer's failures to act have devastated us all. This tragedy was completely preventable. If only they had done something, Your Honor, anything, to shift the course of events on November 30th, then our four angels would be here today, and Justin would be getting ready to celebrate his 20th birthday on the 18th of this month. If only, Your Honor, they had taken their son to get counseling instead of buying him a gun. If only they had secured that gun. If only they had spoken up that day in the counseling office. If only they had checked his backpack. If only they had taken him home or taking him to counseling instead of abandoning him at that school, I wouldn't be standing here today. And the facts of this case, both cases, have been deeply disturbing. What I would like to share with the shooter's parents is an example of what love looks like between a mother and her son. This is what Justin wrote to me on one of the last birthdays that we celebrated together. Dear Mom, words cannot describe how thankful I am for you. You have been nothing but an amazing mother for as long as I can remember. Thank you for being a role model. Thank you for showing me what it's like to never give up. You inspire me to do better each and every day. I love you so much. Love, Justin. It is devastating and heartbreaking that it doesn't appear that either of you cherished or even wanted your son. But I wholeheartedly wanted and cherished mine. You have failed your son and you have failed us all. This failure had deadly consequences that can never be undone, that can never be made right. I am asking, Your Honor, for the maximum sentence allowed. Thank you.
Thank you for being here.
Thank you.
Good morning. Craig Schilling, Justin's dad. So, Honorable Judge Matthews, for the second time in 6 months, I find myself standing in front of a packed courtroom, a victim. This time, I'm here to address a different judge and the parents of the deeply disturbed teenager that murdered my son. This is my opportunity to try to describe just how much the horrific event that took place back on November 30th, 2021 has impacted my life. It's my belief that an impact statement should not just describe how this particular event impacted me. I feel that it should also be impactful towards all who hear it. And in your case, Judge, I hope these words impact you in a way that influence your decisions here today. As I look around at all the lawyers, police officers, media folks, and other victims, I can't help but ask myself, what could I possibly say that this whole scenario doesn't already say? This is messed up. Most people will never have to make a victim impact statement for the rest of their lives. And the fact that the victims speaking here today are doing so for the second time in 6 months should speak volumes in and of itself. This is not normal. Living a life like this is not normal. So how does it affect a normal guy? To be completely honest with you, it remains a rather difficult and uncomfortable question to answer. In my previous impact statement, I've expressed many of my day-to-day struggles, from uncontrolled emotional outbreaks to sleepless nights to not being able to focus on normal daily tasks. Yeah, it's fair to say that I live every day with pain, anger, heartache, regret, anxiety, stress, you name it. They are all there, wreaking havoc in my once normal life. They say that time heals all wounds. Well, we're coming up on 2.5 years now, and I can assure you that the wounds are still as fresh as they were on that tragic day. And with this hole that has been left in my life still glaringly obvious, I fight every day to not lose more of myself within that very hole. I have spent the last 30 years of my life busting my butt to support a family, raise children, and try to set myself up for some peace and quiet in the golden years of life. But the unthinkable has happened. And that peace and quiet I've worked so hard for may never come to be. At least not to the degree that I've always imagined it. Literally every single aspect of my life has been affected by this tragedy. And I could spend a long time describing in detail just how it has impacted me, but it seems like it would be way easier for me to just tell you how this tragedy hasn't impacted me, because there's simply nothing on that list. Now that the verdict is out on this monumental case, I feel strongly that it has caught the attention of most parents across the country. The overwhelming facts in this case were all that was necessary to prove that James and Jennifer Crumbley not only neglected their son by failing to get the necessary mental care that was clearly needed, but provided him the very tools necessary to carry out those heinous acts of violence. It was these very facts that allowed not just one, but 2 full juries to find both of them guilty of involuntary manslaughter. I will always maintain the opinion that the facts that were presented in these cases were strong enough to convince any jury of their guilt, and that the verdict would have been the same regardless of where the trial was held. As I've maintained throughout the course of the past couple of years, being the parent of a murdered child tends to cause you to seek out the maximum penalties allowed for each guilty verdict derived from any of the criminal charges. I think this stance is completely justified, and would be so for any parent in the same position as mine. However, this is a court of law where a person is innocent until proven guilty, and the defendant has the right to dispute the facts of the charges against them. That being said, during the course of both of these trials, I did my best to capture every word and process all the facts. This is important because there is value in these facts, not just in the thousands and thousands of man-hours invested in gathering, processing, and organizing the evidence, but also for being able to use that evidence to establish the cold, hard truth of this tragic situation, that James and Jennifer Crumbley failed in their parental responsibilities as they pertain to the shooter, who was their son. The cold truth that shows that they did nothing to address the obvious signs of the deteriorating mental state of mind clearly present within their son. And of course, the very hard truth that shows that they provided their son with exactly what he wanted to use to do what he did, and failed miserably to secure it properly. One would probably think that in order for something like this, or something of this magnitude to even happen at all, there would have to be a ton of things that went wrong. Although there were some things that definitely went wrong that day, for several of those things, I believe that if they had been handled correctly, we wouldn't be here right now. And James and Jennifer Crumbley carry the bulk of the responsibility needed to handle those things. During their trials, the overall similarities between the two were evident, and I believe this is why they were both convicted. Numerous facts that were the same for both trials showed clearly that the parents failed their son, and ultimately the entire community. With Jennifer, the thing that resonates most is that she stated that even knowing what she knew now, she still wouldn't have changed a thing. I almost died when she said that. 4 precious lives were lost at the hands of her son by means that she helped provide. She saw the drawing of the murder drawn with the hands of her son. She sat and heard the request of the counselor and did nothing. And she still says that she wouldn't have changed a thing. I just don't understand how someone can be that purpose to make a statement like that. The blood of our children is on your hands too. This is but one reason why I feel that Jennifer should receive the maximum amount for her sentence. The facts presented should be all the others that you should meet. With her distinct lack of remorse and overall unethical understanding of the tragedy, I feel that the maximum amount of time available is needed for her to be able to fully comprehend the gravity of her actions and the lack thereof. With James, there were a couple of things that jumped out at me in particular, but one thing that is the toughest to digest is the fact that when the verdict was being read, he sat there and shook his head in total disagreement, as if to suggest that the jury was wrong and that there were no grounds for a guilty verdict. I was dumbfounded to see him shake his head with such disbelief, an action that only suggests that he truly believes he did nothing wrong. How could you possibly think that? 4 precious lives were lost at the hands of your son by means that he helped provide. He saw the drawing of the murder drawn with the hands of his son. He sat and heard the request of the counselor and did nothing. I just don't understand how someone can so arrogantly dawdle in a pool of self-pity without being able to say one thing to justify themselves. The blood of our children is on your hands too. This is but one reason why I feel James should receive the maximum amount for his sentence. The facts presented should be all the others that you need. With this distinct lack of remorse and overall unethical understanding of the tragedy, I feel that the maximum amount of time available is needed for him to be able to fully comprehend the gravity of his actions and the lack thereof. Throughout the course of all of this, and I'm talking from way back in the beginning, I just can't get over the fact that this tragedy was completely avoidable. There were some pretty obvious signs that were completely overlooked, and the bulk of the responsibilities to address those signs lied on the parents, and they failed. Across the board, failed. They willfully ignored the cries of their child and selfishly put themselves before helping him. This type of blatant disregard is undeniably unacceptable. It is a large reason why the events of that day were able or were allowed to happen, and another reason why I feel they both need the maximum amount of time available to be able to fully comprehend the gravity of their actions and the lack thereof. We all know that having children is a big responsibility. Although extremely rewarding, it starts out pretty scary. I mean, let's face it, they don't exactly come with instructions. There's no mute button, and unfortunately, no pause or rewind buttons either. Oh yeah, and there are times in the beginning that they really snap. Yet we still have them. We still want that responsibility, even though it's not very clear what it all entails. But how can we accept that responsibility and not act responsibly towards that child? It doesn't add up. A child, even if he is an oopsie child, deserves the same amount of love, compassion, and care that every other child gets. A child deserves someone who is confident enough to lead by example. Because let's face it, it wasn't that child's choice to come into this world. You made them, and it's your responsibility to teach them how to live. It's your responsibility to set a good example. It's plain and simple, just like that, ladies and gentlemen. And the sooner we can figure that out, the better we all will be. Being a parent is hard work, but if it's done correctly, it can be the most rewarding work you ever do. There is no one that can tell you how to do it, because each child is so precious and unique. I mean, there's no other one like them in the entire world, and that says a lot. So cherish your one and onlys, and never give them up. Never give up on them, excuse me. The results of doing so can be catastrophic and can affect the lives of so many other people. So I ask for you all to go home today and hug your kids and make sure they know you are there for them and make sure that they are all right. It's so crucial for the whole of our society. Thank you.
Thank you, Mr. Shulman. Raina, right?
Yeah.
Raina, say Julie.
Our 10-year-old little brother had to learn how to write a eulogy for his sister before he even learned how to write essays. November 30th, 2021, all our parents did was send us off to school. Yet the next time they see Hannah is to recognize her lifeless body in a medical examiner's office. I met up with Hannah and a friend during school that day. When we split ways to go back to class, I just looked back and smiled. I didn't say goodbye. I never got to say goodbye. I never got to remind her that I love her, that she's my everything, the person I want to walk through life with side by side. I thought our future was a given. Of course, she'd play her first high school basketball game that night, get ready for all the other school dances, have her JV and varsity season for all the sports she played, get her driver's license, play her lacrosse season, have her first date, prom, graduation. She never got a chance for any of that. She didn't even get her 15th, 16th, 17th, or 18th birthday. These are only some of the high school experiences she never got to have, but it is absolutely nothing compared to the rest of everything she had going for her future. That list is eternal. Hannah's life had only started to begin. 12:51 p.m., November 30th, 2021, that was the moment I became aware of the fragility of her mortality. Hannah, who was healthy, Hannah, who was only 14, shot 4 times. 12.5% of the bullets shot that day were at her. She took her last breath in her own pool of blood in a school she hadn't even been in for 3 months. Alone for 7 minutes while police passed by her, bleeding out as a security guard failed to put a tourniquet on her, dying as EMS took more than 10 minutes after the shooter had been detained to even give aid to her. Our Japanese grandma would often worry about anything bad happening to us because she knew how dangerous it is here compared to Japan. She told me on FaceTime that Hannah would respond with a laugh, saying, "Don't worry, I'm a fast runner, I'll outrun them." It wasn't possible for Hannah to outrun the bullets bought by you, Jennifer Crumbley, which were fired by the 9mm Sig Sauer that you, James, gifted to your son. Both used to murder Hannah, Justin, Tate, and Madison. The fact is, no matter what you try to make yourself believe, Jennifer, you did fail as a parent, both of you. To love and to be loved, that is the human experience. It was up to you guys to show your son that. Instead of giving quality time and compassion, you gift your son a gun you knew caused extraordinary damage. There's a reason your kid didn't use the other 2 firearms or the .22 ammunition you own. I believe your actions cannot even be confined into the word failure. Your mistakes created our everlasting nightmare. So yes, you are still a danger to society, because even after serving 2 years, you have yet to admit to your wrongdoings. And we know that when we do not learn from our mistakes, we repeat history. You call yourself a victim. The difference between you and Hannah, Justin, Tate, and Madison, you and my family, you and all the students there that day, is that we didn't have a hand in causing this. You caused the most cruel thing I could ever imagine. You guys made loving Hannah so painful. That is not a narrative, that is reality. For that, unless you have a time machine or the ability to stop time, there is no existing punishment or rehabilitation that will ever be enough. Because there is no way that the one life I have, I now have to live without Hannah, my little sister, my best friend, my other half. To me, that makes the maximum sentence being 15 years too short. Hannah didn't even have 15 years to live. Jennifer, you stated that even after knowing everything you know now, you wouldn't do anything different. I cannot fathom that. I would do anything to hear her footsteps coming up the stairs. You don't have to roll your eyes, it's on video that she said that. To not have an empty seat at the dining table, to have her come into my room and ask which clothes to order, to see her napping on the couch, to laugh and share a look when we accidentally say the same thing at the same time. There's not a day that goes by that I wish I hadn't run out of that building. If I knew what I know now, I would do everything differently in a heartbeat. I hope time makes you think differently. One day, I hope you would have chosen to care for your son, teach them how to love and to be loved, that you would not choose to buy the bullets that enter children's bodies, that you would not choose to omit relevant important information to the counselor Sean Hopkins and Dean of Students Nicholas Ejak that could have helped their incompetent brains in one shared brain cell to decide to act and search the backpack, that you wouldn't still choose to hide from accountability when you're the reason we had to hide for our lives, that you would choose to save Hannah, Justin, Tate, and Madison. Like my mother said, both of you should implore that even on your worst days, it's the tomorrow Hannah doesn't get. The tomorrow she wanted to live so badly, the tomorrow that she should have. I can never do Hannah justice when talking about her, which is all I want to talk about, and yet I would need a lifetime and still wouldn't have the right words to capture incandescence, humor, thoughtfulness, kindness, or loyalty. She's always there for you, helping without a second thought. She's always sharing, whether it's her smile, her food, her clothes, her crafts, her joy. She's funny. It's a given. She brings people together. Whether it's her contagious laughter or sarcastic wit, you will be laughing right along with her. She's noticing the small things, new shoes, new haircut, cute jewelry, but even more importantly, she makes you feel seen. She's extremely spirited. Her energy is unmatched on or off the court. She dresses up every holiday, every spirit day, the first one to put up Christmas lights, or any lights for that matter, not even realizing she was a light for so many others. She's the one who would not only playfully roll her eyes and smile when I would say I'm taller than her as I look up to her. Not only did I look up to her physically, because yes, she was taller, but as a whole, as a human being. She isn't perfect, but she's Hannah, and to me that's as close as you can get. I can't convey what losing Hannah has done to me. I miss her with every breath I take. I think going forward without her is something I'll never be able to fully navigate. I believe the word sad is inappropriate to use because it does nothing to capture the hurt or the way my soul shattered. I've never felt every atom of my body igniting from anger until Hannah was murdered. I didn't know what it was like to want to stop waking up in the morning until she wasn't here. I have never known pain that is forever until seeing Hannah in a casket. I didn't know it was possible to feel so isolated even when you're surrounded by people. I didn't know how it feels to not know yourself at all. I have no idea who I am without Hannah. She's my happy, she's my home. I look for Hannah in everyone I meet, every place I go, and it's exhausting when I'm met with disappointment every time. But it's the world, it's all the people she would have met. I grieve for them too. To have that chance of Hannah being in your life taken away from you is a tragedy in and of itself. She's more of a person than you two combined times a trillion could ever even hope to be. But when the day comes that you re-enter society in 13 years, I hope you live more like Hannah. I hope you live every moment to the fullest like Hannah. I hope you laugh every day like Hannah. And I hope you love unconditionally like Hannah. That's it.
Thank you, Rita. Mr. St. Julian.
Thank you. I find myself in a rather odd state of mind today. Rather emotionally blank right now. Part of that is having to do this again. Part of that is I'm mostly a private person, and the idea of having to pour my heart out again is irritating. And I can't match the eloquent words that have come before me in the previous impact statements. So I'll limit my words today. The defendants, through their choices, through their indifference and gross negligence, enabled their son to murder my daughter Hannah and 3 other children. They chose to stay quiet. They chose to ignore the warning signs. And now as we've heard through all of the objections, they continue to choose to blame everyone but themselves. Every single objection, I think, that the council said this morning put the blame somewhere else, their son, not them. I stood before the court several months ago and spoke about the impact that Hanas' murder had on myself and my family. Nothing has changed since then. It's impossible for me to truly convey the complete impact of my daughter's loss. Hanas' murder has destroyed a large portion of my very soul. I've said these words before. It's still the truth. I remain a shell of the person that I used to be. I think of her and miss her constantly. Every day is a battle to attempt to move forward, struggle to get out of bed, to go through the motions of everyday life. Simple everyday sights and actions bring pain, as I think what it should have been like with Hannah there with us. I think of all the good times that we've shared together as a family, and more on all of the memories that will never be. I will never think back fondly on her high school and college graduations. I will never walk her down the aisle as she begins the journey of starting her own family. I am forever denied the chance to hold her or her future children in my arms. A few words describing Hannah can in no way fully capture her truly beautiful, caring soul, or impart her unlimited potential. Hannah was absolutely beautiful and thoughtful person. She was always the first person to notice when someone had a problem and the first to go out of her way to offer help. She was incredibly curious and talented. She continually tried new things. She crafted homemade jewelry, tried cooking her own recipes, and played several sports. She was a record holder in track and a leader of her school volleyball and basketball teams. She also hoped to join her older sister on the lacrosse team in the spring. She had aspirations of her career dedicated to helping people. All of this is lost because of the defendant's actions and choices. My position regarding the defendant's sentencing and their future has evolved through their trials. At first, I was focused on the importance of getting a guilty verdict, to have the message conveyed to the public that this type of behavior and choices are not acceptable. I didn't have strong feelings about their sentencing. It was just something that would be determined by the system. My view, however, has changed as the defendant's level of defiance has grown. Instead of acknowledging any mistakes, they continue to show no remorse. They take no accountability. They and their lawyers continue to try to change the narrative and portray the defendants as victims of the prosecution team. They blame everyone but themselves and make threats of retribution. The facts have already been presented. The jury has found them guilty. Multiple juries have found them guilty. Hannah, Madison, Tate, and Justin are the ones who have lost everything, not the defendants. As such, I ask this court to sentence the defendants to the maximum allowable penalty of 10 to 15 years in prison. Thank you.
Thank you, Mr. St. Julian. Thank you for being here. Mr. Muir.
Tate Myers' dad. First of all, Mark, Karen, the whole team, strong work. Everybody said you couldn't do it, and you did it. For our family, it's not time to celebrate. This tragedy has taken an incredible toll on our family. So our family's not going to give the Crumbley family a second of our time up here. It's time to turn our focus now. This is the low-hanging fruit. Now it's time to turn our focus to Oxford schools who played a role in this tragedy. You know, I hear this morning when we're listening to all the objections and hear Sharon talking about protecting the criminals' civil rights, constitutional rights. Where's my rights being protected? I fight for everybody in this room. My rights aren't being protected. Criminals' rights are more important than our rights, my rights. We are ready for our government to perform an investigation on this tragedy. Many don't know that our government has not investigated this murder. A pre-shooting investigation, a day of the shooting investigation, and a deep dive investigation into the horrible response to this tragedy, the disrespect shown to us families. The simple things, like trauma training for somebody like a Sheriff Bouchard, who we got to talk to on the day that we got to go identify Tate. And he referred to Tate as a girl because he was too busy that night working to cover it up, instead of learning about every kid, Tate, Hannah, Justin, and Madison. It's time for the whole truth to come out. It's time to learn from this, from the purchase of the gun to the response. That's when real change happens, is when we can look at something and we can evaluate it, apply lessons learned. That's when real change happens. So Hanas, St. Juliana's family ready for the truth? Justin Shilley's family ready to hear the truth? Nicole Baldwin's family ready to hear the truth? Tate Myers' family's ready to hear the truth. Quit denying us that. It's time to drive real change from this tragedy.
Thank you, Mr. Mayor.
That concludes the victim impact statements.
There's no one else. You're not presenting anybody else.
Correct.
Ms. Smith, what would you like to say on behalf of your client?
Your Honor, my client would also like to make a statement. Would you like me to?
Of course.
Okay.
Of course. You may both allocate.
Thank you. I didn't know which order you wanted to go.
Either way first. It's up to you. You were your client.
Would you like to go first, or would you like me to go first? I can go first. Okay. Do I stay here?
You can stay there. Yeah.
Your Honor, is there any way she can have this handcuff off? Because she has multiple pages.
I'm okay. I'm right here. I don't have to shuffle.
You're okay?
Okay.
I don't know if I'm allowed to.
Okay, it's okay. She said she's okay.
It's okay.
Go ahead, Ms. Crumbley.
I sit here today to express my deepest sorrow for the families of Hannah, Tate, Madison, Justin, and to all those affected on November 30th, 2021. The driving weight this has taken on my heart and soul cannot be expressed into words. Just as I know there is nothing I can say that's going to ease the pain and suffering of the victims and their families. There's a quote I heard that rang true. Grief. For those of you who understand, no explanation is needed. And for those of us who do not, no description is possible. I've taken countless nights of lament over the anguish and shame I carry, knowing what my son did, the harm he caused to innocent lives, the families, and to the entire Oxford community. I pray all the victims are the embodiment of God's mercy and peace, and that He heals your broken spirits. When I was on the stand, I was asked if I would have done anything different. I was horrified to learn my answer I would not have was completely misunderstood. That answer is true because my son did seem so normal. I didn't have a reason to do anything different. This was not something I foresaw. That was the intention of my answer and how I interpreted the question. With the benefit of hindsight and the information I have now, my answer would be drastically different. If I even thought my son could be capable of crimes like these, things would have absolutely been different. Even worse, when I learned during the police investigation that he had been planning a school shooting before November 30th. He was not the son I woke up. He was not the son I knew when I woke up on November 30th. The Ethan I knew was a good, quiet kid. He loved his pets, family vacations. My husband and I used to say we had the perfect kid. I truly believed that, and that's who I saw and thought I knew. As the details started emerging during discovery, I was horrified to learn concerning behaviors my son was reported doing at school. Refusing to take a makeup test he told us he took. Sleeping in class. Drawing pictures of guns on his assignments. Writing, quote, "My family is a mistake." Watching a video in class of a mass shooting that fatal day, along with internal communications that took place between his teachers and counselor, Mr. Hopkins. That he is, quote, "on my radar," and, quote, "he seems to be having a rough time," was never disclosed to us, his parents. The school claimed this was not abnormal behavior because of the pandemic and Oxford being a, quote, gun community. To say I was furious to learn this information is an understatement. This is not normal behavior to us and very different than what Ethan led us to believe was happening at school. Not only were you left in the dark about previous concerning behavior, but in the counselor's office that morning, none of those previous issues were brought to our attention. I can't stop thinking, had they been, the conversation that morning would have been much different. That we would have taken a deep dive into what's really been going on with my son. I wonder if Hopkins and EJAC have those same regrets too. Instead, we are led to believe, not only from Hopkins and EJAC, but from Ethan as well, that this was an isolated event. We felt confident in trusting the professional's advice to let him stay in school that day. Quote, he does not pose a threat to himself or others. It was suggested that him being around peers would probably be good. We agreed. We were never asked to take him home that day. If that was discussed as the best course of action, we would have obliged. The prosecution keeps saying we didn't give them the big picture that morning in the counselor's office. But what they failed to acknowledge is the bigger picture the school did not give us. I'm not the same person I was prior to November 30th, 2021. This tragedy has changed who I am and has taught me some very valuable lessons. It said in suffering we gain wisdom. I've also gained God. In the quiet hours of my cell, I prayed to Him about the deep impact this tragedy has had on the families and the endless pain no one should ever have to feel. For it is God who holds a true understanding of our pain. I've also learned to depend on Him for peace and strength. Alone, I'm not strong enough. I've learned that we cannot tell or predict what will happen to us in this life. One day you wake up and everything can change. We can, however, decide what happens in us, how we take it, what we do with it. And that's what really matters in the end. That's the test of living, is how we take the unimaginable, the tragedies, the raw hardships, and make them a thing of worth and beauty. I've also learned to never think this could not happen to you, and stereotype that bad kids come from bad parents. The prosecution has tried to mold us into the type of parents society wants to believe are so horrible, only a school or mass shooter could be bred from. This is a very fatal assumption to have. We were good parents. We were the average family. We weren't perfect, but we loved our son and each other tremendously. Everything we strived for was to make sure our son had the best life we could give him, to grow up with traditions and experiences we had, to be the best person he could be. I know we did our best. The love I have for our son, mixed with regret for not seeing what was ahead, weighs heavily on me. My point is, this could be any parent up here in my shoes. Ethan could be your child, could be your grandchild, your niece, your nephew, your brother, your sister. Your child can make a fatal decision, not just with the gun, but a knife, a vehicle, intentionally or unintentionally. If there's anything the general public can take away from this, is that this could happen to you too. The tragedy has taught me the true meaning of unconditional love, as I watch my parents still love and care for me wholeheartedly, no matter what has happened. If there's nothing else I can do right in life, I do still love my son unconditionally, and perhaps that is my purpose. Your Honor, I don't envy the decision you have to make today. I understand this is a novel case, and punishment expectations are high, not just from the prosecution, but from all those affected as well. The heartbreaking journey these families have endured. Hang on, I have to back up. I missed my most important. I need to cross. The most valuable piece of wisdom I gained is the power of forgiveness. To forgive the prosecution for the slander and hate against me and my husband. Ms. McDonald, Mr. Keast, I have hated you with deep anger, but hate is too heavy of a cross to carry. I need to be set free of that burden and recognize that you are people just like me, imperfect, but a child of God. I know He wants good things to happen to you, and in any conflict, whatever the circumstances, He is there loving both sides. To the victims and the families, I stand today not to ask for your forgiveness, as I know it may be beyond reach, but to express my sincerest apologies for the pain that has been caused. Your Honor, I don't envy you in the decision you have to make today. I understand the punishment expectations are high from all sides. This heartbreaking journey the families have endured is more than anyone should have to bear and acknowledge in its full depth. My time in confinement has been filled with deep remorse, regret, and grief over this tragedy. I have taken this one day at a time, trying to survive, navigate, and cope with the endless heartache, pain, and grief I feel for the families of Hannah, Justin, Madison, and Tate. I have also lost myself over my son's wrongdoing. I've been shredded by the public opinion of me, shamed as a horrible parent, pained to be a terrible person. But the worst hell I carry is my own self-judgment, remorse, and deep regret. I've been criticized I don't show emotion, I'm unsympathetic, I don't cry enough, but alone I grieve. And if you were to look into me internally, you'd find I've died on the inside. I will be in my own internal prison for the rest of my life. Your Honor, I ask you to take consideration that I have been locked in a cell 23 hours a day, essentially in solitary confinement, for over 28 months, and that the court finds a fair and just sentence for me.
Thank you.
Yes, Your Honor, thank you. Your Honor, as I pointed out in my sentencing memo, this was a no-win case. When we walked in the door, there are no winners here. Every single person goes home and here.
Agreed.
And there's also no limit on the amount of sadness, grief, and horrific emotions that are felt across the board in this case. And when Mrs. Crumbley does express remorse, when she expresses sadness, there's a tendency, and there has been a tendency, for people to say she's shifting from sadness to the victims and putting it on herself. She's not doing it. There's an abundance of sadness. There's enough sadness to go around for all of the victims, for Mrs. Crumbley, for everyone involved in this case. It's not surprising that the victims have come in and obviously want the maximum sentence. There has been a narrative throughout this case that they believe is true. And this court knows that there is other information that was not a part of this case. And I believe this court knows the defense was hugely hamstrung, and I think the court was pained at times over what to do.
I guess I'm not sure what you mean.
I'm talking about not being able to call the medical professionals, not being able to call the shooter to the stand, not being able to cross-examine on various pieces of evidence.
I'm not convinced the shooter would have helped you.
Okay, well, all of those are obviously issues, but there were things that hamstrung the defense. And I do believe
the forensic records.
I do believe the shooter would have helped, and I do believe the forensic records would have helped. And I understand the court has already ruled on that. I understand that. I think the tendency, though, after hearing the narrative that has been made public, has been to make Jennifer Crumbley sound like a monster, to vilify her, to make her sound like a horrible mother, an evil person. And the truth is, it's an effort to put her in a category of other, to say this is not something that could happen to any of us. And it is. It is something that could happen to any of us. And people fail to realize what the sentencing memo shows the court through numerous letters of support, that Mrs. Crumbley does have a kind heart. She does have compassion. Night after night, crying not for only herself and her son, but also for the victims and for what her son did and what she will live with, knowing he did, and what she missed all the years forward. At the end of the day, we asked the court to look at Mrs. Crumbley's role in the offenses. We asked the court to consider that while she did not oppose having a gun in the home, she was not the person who was responsible for storing the gun and believed it was being stored properly and that it was locked. Mrs. Crumbley obviously testified, and all of the evidence at trial showed she believed there was a string lock, a cable lock placed on the gun, on the weapon.
I don't mean to interrupt you, but that has really troubled me from your sentencing memo, because you spent a lot of time talking about the fact that she didn't know anything about the gun. She didn't lock it. She wasn't responsible for it. But at one time, she was texting her husband to see whether or not he got the gun and how much it was. She posted pictures of it as her son's Christmas present. She shot the gun. And I don't know if you're aware of this. I don't know if either side was aware of this, but the first jury determined that there was a claim that the gun was the responsibility solely of defendant James Crumbley. And Mrs. Crumbley testified that when she returned from the range with the shooter on November 27th, it was the defendant James Crumbley who was responsible for the 6th hour when he retrieved it from the car and was supposed to keep it safe. The first jury recognized that the GPS admitted in the case shows that even prior to the defendant James Crumbley returning to the house, the shooter was videotaping the unlocked Sig Sauer in the kitchen of the home. So that's not true. That's not true. She also testified that a key to the cable lock was kept in the beer stein in the kitchen, but it's clear that the cable lock was clearly never opened.
Your Honor, first of all, the jury's finding about the timing of the GPS and when the gun video was made is not correct. The evidence at trial did not support that. We know that's not correct. Mrs. Crumbley left the gun in the car so that James Crumbley could put the gun in the house and store it correctly. Mrs. Crumbley, there were multiple cable locks in that house because there was more than one cable lock. There was not just the cable lock that was on the Sig Sauer. There was more than one.
I didn't recall that.
There were not more than one found, but whatever Ethan Crumbley did with the cable lock from the Sig Sauer, we don't know.
The gun wasn't locked.
Your Honor, factually, during Mrs. Crumbley's trial, it was not proven that the gun was not locked. I don't know what happened at James Crumbley's trial.
You know about his statements. The gun was never locked.
Whose statements?
Mr. Crumbley's statements.
Mr. Crumbley and Mrs. Crumbley talked about how the gun had been locked in all of the evidence I saw. Well, Your Honor, obviously we have factual disputes.
Go on. I don't think the evidence has shown that she had no involvement with the gun.
I'm not saying no involvement. I said she supported the gun. She didn't object to the gun. But when it came down to it, probation writes in her narrative that she taught her son how to use the gun, and it's very obvious watching the evidence in the trial that she was not the one teaching him how to use the gun.
There's no evidence that she taught him how to use the gun.
When Mrs. Crumbley spoke, she acknowledged what the testimony was at trial about all of the different things that she wished had come to her attention from the school employees. And the prosecutor's office has said that the proposal the defense has made regarding Mrs. Crumbley is a slap in the face. And what's truly a slap in the face, not only to the victims in this case, but also to the Crumbleys, is how much the Oxford schools did fail the Crumbleys and all the victims. Because if Mrs. Crumbley had been presented any of those 5 things, things would be different and we would probably not be here today. I am asking this court, I know the court of public opinion is running high right now. Emotions are running very high. There are many, many complicated issues with this case. It is a dynamic and different case than most cases. Mrs. Crumbley does have a good heart. This is a woman who had no felony history. This is a working mom who was very busy, did have a hobby.
I don't think there's anything wrong with this thing.
I'm just saying, largely the evidence at trial were some of those things, and Mrs. Crumbley did have an enormous amount of love for her son, and what she has been painted out to be in the media and throughout this case, and even throughout the victim impact statements today, is just not congruent with the people who know Mrs. Crumbley and know her heart. It's also not congruent with the text messages she sent right after the shooting about how she wished she would have died instead of one of the kids.
I don't think the verdict was about how feeling she is or how sad she is. I think the verdict was about the behaviors that led up to that day.
Well, there has been an enormous amount of criticism about whether or not she's sad enough, and there was cross-examination extensively about whether she cried or not enough on the stand, or when during the videos that were played of police interviews and things like that. And then, on the same hand, when
I don't doubt that they were both shot. I don't doubt that.
And at the end of the day, though, when she did cry, there was an objection about crying. And so Mrs. Crumbley from the very beginning has been damned no matter what way she went. This was the most horrific thing that could have happened to the community, to the victims, to these families. Absolutely horrific. At the end of the day, however, it's a unique and complicated case, and that is why I proposed the sentence I did. I don't believe the sentencing guidelines take into account the very unique situation that we have in this case with a young man who will be in prison forever. I'm asking the court to keep that in mind, and please keep in mind the other arguments throughout the memo.
I think you know that I read everything you send me.
I do, and I appreciate that. Thank you.
Do you want to respond now, or do you want to get a counter from the signing first?
I prefer just to be able to respond once, Your Honor.
Are you okay with that?
That's fine, Your Honor.
All right, would you like to address the court, or would you like the client to address the court first?
Would you like to address the court, James?
I would.
Yes, Your Honor. Mr. Crumbley will address the court. For the record, he does have something typed out that I typed out for him, so it was bigger. It's easier for him to read, Your Honor.
Okay.
You can't. No, she said she cannot tell them to go. He would, Your Honor, there was some confusion about whether or not he could get his second handcuff off. I was just clarifying. The court said she cannot tell the sheriff's office.
Does he have to keep on handcuffed?
Yes. I was just clarifying, Your Honor. Thank you.
Before I address this court directly, I want to do something that I have never been able to do throughout this time, until now. I want to say I can't imagine the pain and agony that for the families that have lost their children and what they're experiencing and what they're going through. As a parent, our biggest fear is losing our child or our children. And to lose a child is unimaginable. My heart is really broken for everybody involved. I understand my words are not going to bring any comfort. I understand that they're not going to relieve any pain. And quite frankly, they probably just don't believe me. However, I really want the families of Madison Baldwin, Hanas St. Juliana, Tate Myers, and Justin Schilling to know how truly sorry I am and how devastated I was when I heard what happened to them. I have cried for you and the loss of your children more times than I can count. I know your pain and loss will never go away. Part of you will be missing forever. But please know that I am truly very sorry. I am sorry for your loss as a result of what my son did. I cannot express how much I wish that I had known what was going on with him or what was going to happen. Because I absolutely would have done a lot of things differently. Again, my heart pours out to every single one of you. It really does. Judge Matthews, I'm not gonna overdo a lot of things that were already said. But I know the full amount of pressure that you have on you and the responsibility that has been placed on you throughout this case. I have the utmost respect for you, and I'm simply going to ask that you sentence me in a fair and just way. You presided over my trial and heard the evidence that was presented against me. You know that what my son did, I was not aware of, or that he was planning it, or that he obtained access to the firearms in my house. There was absolutely no evidence that suggested that. As my attorney has told you, I've been on lockdown for 23 hours a day. I've not been able to speak to my son since November 30th, and I have not been able to speak with my wife since December 3rd. I know that I have experienced pales in compassion to what those families who've lost their children and countless other victims experience every day because of what my son did. But I want you to know I too grieve for everyone, as I have explained. For everyone that's been affected by what my son pled guilty to doing. And I'll continue to feel this pain for the rest of my life as well. If I could go back and change things, if I could go back and do things differently, and maybe none of us would be here today. So again, I ask Your Honor to impose a just and fair sentence based on the truth about what you heard during my trial. I'm asking the court to sentence me to time served and place me on probation for the maximum time allowed with the GPS tether for as long as the court deems necessary. I also want to address one last thing. And that's to what Tate Myers' dad said. It is time that we all know the truth. We have been prohibited from telling the whole truth. The whole truth has not been told. And I'm with you, Mr. Muir. I too want the truth. Because you have not had it. You have not had the truth at all. The truth has not been presented to you. Thank you.
Mr. Crumbleys. Are you wanting to switch? Go ahead.
Thank you, Your Honor. Thank you, Your Honor. I did submit a sentencing memorandum, Your Honor. I'm not going to belabor the points that I made in my memorandum, as I do believe that it was thorough. However, I do want to note for the court that, especially in statements that have been made about James, that he lacks remorse, that he doesn't feel bad, that he's trying to put off responsibility on everyone but himself, that he's allegedly made threats toward the elected prosecutor. Your Honor, in some of the same calls that the prosecution has tried to use and has quoted in their own sentencing memorandum and attached as exhibits to their memorandum, as I noted in my sentencing memorandum, Your Honor, James also said in those very same calls that he wished that he had known what his son was capable of. That if he had known, if he had been made aware of these things, if he had known that his son had obtained access to a firearm, that maybe he could have saved the 4 children's lives. That maybe he could have saved a lot more than that. Your Honor, there has never been a time that James Crumbley has not acknowledged what happened in this case. He has felt horrific grief for not only the families, but for the people who have been affected. He's grieved for himself, for his own child. And while that may not be something that is a popular statement to make, he's grieved for the child that he believed he had. Not the child who pled guilty, but the child that he believed he had on the morning of November 30th when he dropped his son off at school. James could not have predicted what his son was going to do that day. He couldn't have predicted because he didn't know that it was going to happen. As James said, Your Honor, you sat through the trial, Judge. You heard the evidence that was presented. You also know that there was no indication given in the evidence presented that James had knowledge of what his son was planning. That James didn't know that his son had been accessing that firearm unsupervised, or that he had access to the firearm unsupervised. Judge, you heard that that firearm was stored legally at the laws at the time, in November of 2021. That there may be differing opinions on whether or not that firearm was stored responsibly, Your Honor, but it was stored legally. It was stored unloaded. It was stored with the ammunition stored separately. Your Honor, James Crumbley did and made the decisions that he thought were right, based on the information that he had, even on the morning of November 30th at the school. You've heard multiple times that James had no knowledge of what his son was intending to do later that day. That even the school officials, the people who were trained, they talked about the special training that they had during trial. Even those individuals said that they did not believe that James's son was a threat to other people, that they had concerns about his sadness, Your Honor.
They had at a minimum concerns about his danger to himself, right?
Correct, Your Honor. Danger to himself due to his level of sadness, that they wanted him to go talk with somebody, but that it wasn't so emergent that he needed to be removed immediately.
And isn't it the reason they didn't want him to go home?
Your Honor, there's some dispute as to whether or not the testimony from the school is accurate as to what actually occurred in that office. And Judge, I don't want to try and retry the case. I don't think it serves anyone or benefits anyone. But I do want this court to be aware, and Your Honor, you observed James during the trial. You're aware that he had difficulties throughout the trial. He showed emotion. He struggled with some of the things that he heard and saw. And
I don't know how anyone could have.
I agree, Your Honor. I agree. And as I've acknowledged numerous times throughout this case and throughout the trial, it is an incredibly emotional trial. Today is incredibly emotional for everyone involved. I echo what Ms. Smith said. There are no winners here. Everyone has lost in this case.
I think that Ms. Smith said in her sentencing memo that it's possible to be sad for everyone here, not just the victims from the Crumbleys as well. It is possible to be sad for everyone.
And I agree with that, Your Honor. I did ask the court to sentence James to time served. I am going to echo his request for a period of supervision with a GPS tether. I understand that the court, we did object to scoring. I understand that, again, the court has significantly strong pressure. The emotions run high in this case, Your Honor. I don't envy what you have to do. However, I am asking that you consider my request. Thank you, Your Honor.
Your Honor, I just have to correct some facts. The allegations that Jennifer and James Crumbley were left in the dark just are not true, and the evidence at trial does not show that. The evidence presented at trial that as late back as March, the 9th, 17th, and the 20th text messages about from their son to Jennifer Crumbley that he was seeing things. In April, his text messages to his friends indicate he asked for help. His mother laughed at him. April 26th, Jennifer told his friend's mother that he was depressed. There were multiple visits to the gun range. There was 2 guns purchased for him. Crumbleys were aware that he was struggling in school, and in fact, they had a rather, I would say, critical fight the night before, which is all detailed, incidentally, and as well as where the gun actually was in the shooter's statements, his plea, and the multiple statements he made to the psychiatrist, the very same things. They stand here and say, oh, if only we could have called them. Well, calling those individuals would have resulted in all of the claims that's inconsistent with what he said, and it's inconsistent with what the psychiatrist testified to in the Miller hearing. So I had no intention of addressing this, but it was brought up, so I feel as if I have to, and I have a duty to do so. They were concerned. The evidence showed that. They were very concerned. They were concerned about the drawing, and they were concerned based on the fact that they were called to school. Jennifer Crumbley's own statements acknowledges she was called to the school. They wanted him to get help. She said she had to go back to work, but they said that he could stay. None of that, by the way, is in dispute, and that she left. This insinuation that if only I had known he was sleeping in class and teachers might have been concerned, then none of this would have happened, is at the core of why you saw 6 people standing here and saying there's no remorse or accountability. And I want to be clear, remorse does not sound like I feel really bad. I'm sure they do. I don't dispute they feel bad. I don't dispute they have grief. That's not the kind of remorse and accountability these victims are looking for. What that looks like is, we messed up. We should have done this and we didn't, and we are very sorry. And that has not happened, which is what we're talking about here, and what you heard the victims say. I don't want to belabor any more than we had to in the trial. I have a deep respect for Ms. Lehman, but the facts of this and the elements of this case simply are not that the prosecution had to show that he had actual knowledge and he could predict and he knew exactly what his son was going to do. Those are not the elements of the crime. It's not what the jury was required to find, and it has nothing to do with their actual conviction. Jennifer Crumbley and James Crumbley were not convicted based on a narrative. They were not convicted because somebody thought they were a bad or good parent. Those 2 trials involved multiple motions and objections over evidence that the court sustained. We did not allow the jury to present the information about Jennifer Crumbley that her lawyer made a strategic decision to, in the middle of the trial, say, open the door, you can bring it all in, was not due to the prosecution's requests or actions. But you can't seek to exclude evidence and then allow somebody to testify to an inconsistent with the evidence. The last thing I want to say is there is case law that the court's aware of about what the court can consider in fashioning a proportional sentence. And we don't give power or authority to victims to decide or render verdicts, with good reason. But we should not, and we cannot, sanitize their pain or the weight of the impact or chalk it up to it's emotionally charged, as if everything that's happened here is because people sitting here are too emotional and they pressure people, because that just simply isn't true. And not only should you consider the weight and the impact of the defendant's actions and inactions, you are required to, pursuant to the case law. It is one of the factors to consider, the severity and the impact of the crime. We've heard a lot about it's not what happened in the school. And while I understand that the negligence, the gross negligence that occurred happened before what happened in that day when he left that bathroom and started firing the 9mm and killing 4 kids. I understand that. But it is absolutely about what James and Jennifer did and what they didn't do, and the gross negligence that caused those acts. This is what it looks like. This is what it looks like. When 2 parents have the ability and are in the best position and have the most knowledge and need to protect other kids, and they do nothing. This is what it looks like. They do nothing, and then they come here today and they claim they're victims of the school, of the prosecution, of the emotional tensions of public opinion. But there were 2 long and rigorous and detailed trials that included multiple victims and witnesses who testified under oath, with hundreds of exhibits presented to the juries, with the safeguard of this court allowing what they could see and what they couldn't see, and they were defended by 2 attorneys aptly and vigorously. That is what this conviction is about. And when fashioning a sentence, it is absolutely critical that you listen and consider the impact of what that gross negligence caused. So we're asking you to exceed the guidelines, because I believe all of the factors pursuant to the case law, with the necessary consideration of the impact of these crimes, justifies you to do. We're asking you, the people are asking you, Your Honor, to consider the devastating impact of their gross negligence that was foreseeable. Help me. Blood everywhere. The world is dead. All the while, a 9mm had just been purchased for him, and 50 rounds of ammunition. Both things can be true, Your Honor. You can fashion a proportionate sentence, but not ignore the unimaginable loss and a grief that these parents are enduring. Because they will never get back another moment with Tate, or Hannah, or Justin, or Madison. And this is what it looks like. Thank you.
Thank you. I guess I would like to say briefly to the families, considering your immeasurable grief, it's completely understandable to hate everything associated with these proceedings. I spent both trials looking out at all the family members, and I wondered to myself, I'm looking straight on at Mr. St. Juliana, whether or not he'll ever smile again. And that's very difficult. I'm very aware of my job in this situation, very aware of my job. Do not be swayed by public opinion, by media, by any of those different things. I can't and will not pretend to understand the pain the families are experiencing, but I did sit through these trials with you. I saw what you saw. I heard what you heard. So I can and will offer my deepest and most sincere condolences for your unfathomable losses. It's as I just said, it's not my role. It's not the role of the court system to make an example of the defendants. However, it is a goal of sentencing to act as a deterrent. These charges are not jury edicts about gun ownership or keeping the gun in a private home. All of the jurors in both trials agreed that they understood that. Parenting is a complex job. Parenting practices around the world share the goals of ensuring health and safety, preparation for life as a productive adult, and transmission of cultural values. Parents are not expected to be psychic. But these convictions are not about poor parenting. These convictions confirm repeated acts or lack of acts that could have halted an oncoming runaway train. About repeatedly ignoring things that would make a reasonable person feel the hair on the back of their neck stand up. Opportunity knocked over and over again, louder and louder, and was ignored. No one answered, and these two people should have and sure didn't. Mr. Crumbley, it's clear to this court that because of you, there was unfettered access to a gun or guns, as well as ammunition in your home. You characterized yourself as a martyr and threatened the well-being of the prosecutor. Mrs. Crumbley, you glorified the use and possession of these weapons. Your attitude toward your son and his behaviors was dispassionate and apathetic. Your response to school staff after a 12-minute meeting was, "Are we done here?" During your trial, you announced that you wouldn't do anything different. I understand that that might have been misinterpreted, but it did cut the victims deep. Because of both of your actions and inaction, among many, many other things, the world is missing out on a top college university will miss out on Tate's star quality football skills, I met Raina, who's wise beyond her years, and she's told us that among many, many other things, community will be denied Hanas' kindness, creativity, and sense of humor. Among many, many other things, the world will miss is Madison's kind and loving soul and the light that reflected her beauty both inside and out. Although a hero in death because of his organ donations that helped so many, we will never know where Justin, an excellent student with vast skills and interests, described as a mentor and a leader, would have left his giant imprint. The impact statements given here and the written statements provided to the court describe the cataclysmic impact the deaths of these children have had on their children. With regard to each defendant, this court has spent night and day thinking about this case, as you can imagine. I've prayed about this case, I've thought about this case, and I've considered the possibility for rehabilitation, the need to protect society, the penalty appropriate to the conduct and goal of deterring others from similar conduct. I have reviewed the pre-sentence investigation reports. I am, of course, sadly familiar with the facts and circumstances of these cases, as well as those surrounding each defendant. The advisory sentencing guidelines in this matter do not capture the catastrophic impact of the acts or inaction in these matters. The guidelines do not take into account the complete lack of insight both defendants have for their behavior to this very day. The guidelines do not account for the severity of the circumstances in this matter. The guidelines ignore the survivors, including shooting victims Phoebe Arthur, Elijah Mueller, Riley Franz, Kylie Osage, Jonna Shudo, Molly Darnell, and Aiden Watson. They were deeply wounded, both physically and emotionally. In addition to the 7 wounded, each of the defendants' gross negligence has caused unimaginable suffering to hundreds of others as a result of what happened that day. Each act or inaction created a ripple effect. Therefore, an out-of-guidelines sentence is appropriate and proportional. The court uses the useful tool of the legislative guidelines, which embody the principles of proportionality, while also taking into account the nature of the offense and the background of each defendant. I believe that the following sentences would be in the best interest of justice and are reasonable and proportionate to the seriousness of the matter and the circumstances surrounding each defendant. With regard to Jennifer Crumbley, it is the sentence of this court, Ms. Crumbley, that you serve 10 to 15 years with the Michigan Department of Corrections. You will have credit for 858 days. State costs are $272. There's a crime victims' rights fee of $130. You and your agents may not have any contact with the families of Madison Baldwin, Tate Myers, Hanas St. Juliana, and Justin Schilling. I will issue another ruling with regard to contact with your son, the shooter. Excuse me. As to defendant James Crumbley, it is the sentence of this court that you serve 10 to 15 years with the Michigan Department of Corrections, that you receive credit for 858 days, that you pay state costs in the matter of $272, that there is a crime victims' rights fee of $130, that you or your agents have no contact with the families of Madison Baldwin, Tate Myers, Hanas St. Juliana, and Justin Schilling. Ms. Wheeler, have I left anything out with regard to sentencing? No restitution has been requested by any of the families at this time, correct?
That's correct.
Thank you. I would like to advise both defendants that you are entitled to appellate review of your conviction and sentence, including that the sentence exceeds the guideline range. This is done by filing a claim of appeal by right, or when you are not entitled to file a claim of appeal by right, an application for leave to appeal. If you cannot afford to hire an attorney to represent you on appeal, and you request an attorney may be appointed for you. You may request an attorney by completing the request for appointment of attorney section of the form that will be provided for you and by returning the form to this court or to the Michigan Assigned Counsel System at the address on the form. If you wish to preserve your automatic right to appeal, the form must be received within 42 days of your sentencing. If you do not submit the form within 42 days from today, you may still file an application for leave to appeal if the form is received within 6 months after sentencing. Do each of the defendants acknowledge receipt of their appellate rights?
James acknowledges receipt, Your Honor. He's completing the form as we speak.
Your Honor, my client is as well. Would the court like the forms here, or would you prefer us to?
It doesn't matter either way.
Okay.
Either way.
Thank you.
Thank you. I'm going to ask that everyone remain seated while the defendants are taken out of the courtroom. I think they're going to finish this one.
They are going to, Mr. Crumbley is going to finish his form, Your Honor.
We'll wait for that.
Thank you, Your Honor.
I would just ask that no one stand up. It makes the deputies nervous.
That was the sentencing of James and Jennifer Crumbley. Just wrapping up now. Moments ago, Judge Cheryl Matthews said both of them will serve 10 to 15 years in prison. Now, we're wrapping our coverage here on air, but if you're not already on the stream, you can join us there, where we'll be joined by our attorneys for legal analysis. We're continuing our coverage of the Crumbleys sentencing, where we just heard each defendant will receive 10 to 15 years in prison. Let's bring in our team of legal analysts now. We're joined today by Richard Convertino and Lillian Diallo. Thank you both so much for being here through the extent of all of these hearings and trials. Reactions to the sentence, Lillian.
I knew she was going to exceed. I could tell she was going to exceed the guidelines. She did as much as she could do. 10 to 15. It is what it is.
Mm-hmm. Rick?
I'm not surprised. We talked about it earlier. I thought she would upwardly depart to conform with the prosecution's request for sentencing of 10 to 15 years. The judge laid a record to protect herself on appeal on the sentence. She said that the sentencing guidelines do not take into account the severity of the circumstances, the other victims that were not included in the pre-sentencing investigative report, or the request for an upward departure. The defendant's lack of remorse in this case was weighed heavily on the judge. She said that it was that they've caused unimaginable suffering. I think the statements by both defendants, certainly like in Jennifer's case in her trial testimony, hurt, and she just made it worse, compounded by her attorney's statement in an attempt, I don't know what the hell the attempt she was doing, but she said in there very curiously that there were additional gun locks that were not discovered, and that seemingly the shooter in this case removed a gun lock somehow and discarded it in mystery land. It was wholly made up. There was no evidence of that. And the judge directly rebuked her and said that that is not true. She rebuked her on that and a couple of other points that she made. But the theme in this whole sentencing from the defendants was outlined by, I think, Tate Myers' dad, who said that's all they've done is throw blame to others. And that's consistently what the trials were about, and that's consistently what they did today. They blamed the school district. Bizarre statement by James Crumbley was that there's the truth. He agreed with one of the, I think Mr. Meary said, the truth hasn't been told. Shannon Smith said that they weren't allowed to cross-examine witnesses. They weren't allowed to use, present witnesses in the trial that would have made a difference. I mean, it was just one offensive statement after another, which it was inevitable that the judge was going to upwardly depart, and I think she put the hammer down appropriately.
Lillian, what did you make of the defendant's statements, especially James, because this is the first time we're hearing from him?
Okay, so you see my voice is doing something. Listen, it's still all about him. It's still all about her. It's not about the people that were slaughtered. You were in the best position in that office on that day to stop this. The school, they acted atrociously to me as well, right? But you're the parents. You have a direct link. It's all about me, me, me. We have, and how dare you talk about the four, name them, right? You could have stopped this. Your outrage and your conspiracy theories and whatever else, we have 4 dead kids. You bought them the gun. Mom, you had something to do with that gun. You get on the stand and say, I wouldn't change anything. It's just outrageous. That's not even the right word, right? I don't even know what it is, right? It could be repugnant. You know, you can call them reprobates, whatever. You know, all these beautiful big words. But the issue is, what did you do as a parent to stop this? You did nothing. You wallowed in privilege. You said, don't tell me anything. The rules don't apply here. They apply everywhere else. Well, let me just say this. The rules apply everywhere. And that's what we have to get to, right? If they would have done one small thing, right? And then for the attorney to try to relitigate the trial, we don't do that.
Yeah.
We have to respect the decision. You might want to cross-examine whomever, right? Jesus Christ, him or herself. That's not the issue at sentencing. At sentencing, we represent the client to the best of our ability and minimize their exposure instead of me, 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 me. It's just too much.
To compound that, Lillian, Jennifer said, we're good parents. She said it again, we were good parents. She said we were average parents. She said that we were an average family. The thing that was most offensive to me that was said by Jennifer that was repeated by her counsel was that this could happen to any of you. And so she made the point, and it was in Smith's closing argument, she said the same thing, that all parents are subjected to this, the wrath of a wayward rogue prosecutor who wants to prosecute them for the illegal acts of a child. Certainly the evidence was nowhere near that, and it was offensive. It was obscene to argue that in front of these victims today. They blamed the schools, they blamed the prosecution, they blamed their son. Jennifer today blamed her husband, who was seated right next to her. Shannon Smith said Jennifer had an abundance of sadness, even though she has some, I don't know, what, malignant narcissist where she can't show emotion. That was one of the things that her attorney said. She's unable to emote appropriately, I guess. They couldn't cross-examine the witnesses they wanted to. The jury's, Smith said this, the jury's findings were incorrect. Now, I don't know what more inappropriate type of thing to say to the judge at a sentencing hearing, that the jury's findings were incorrect, but certainly not a platform upon which you want to argue to the judge who's about to sentence your client. It was just an S show today, and unfortunately, the victims, I think, were offended, and the families were offended by the display of arrogance and hubris by both defendants today.
Another statement that struck me was by Muriel Lehman, James Crumbly's attorney, who said, my client is mourning for his son. He's mourning for the son that he knew before the morning of November 30th, 2021. That felt off, didn't it?
So she has to argue something, right? It's in real time for us. And I can't criticize her. I know as a parent, it hurt to hear it though, right? I was like, ooh, your baby is here. Your baby's actions took 4 that you could have stopped. So, I mean, this whole thing is almost bizarre at the end, right? I just don't understand how we try to relitigate and then say, jury, you got it wrong, and have alternative facts. What is this? The facts are the facts. I don't understand.
Yeah, the judge called both attorneys out on that throughout their statements. But both attorneys did say the testimony of the school officials at trial was inaccurate. I'm not sure what they were getting at, as if there's some other testimony somewhere that would display that. They didn't bring that up. They didn't cross-examine the defendants on any prior inconsistent statements to show that their statements at trial were inaccurate. So they kind of left it out there. And that was what James said. There's one last thing, he said. I have one last thing to say. And the thing he said was that we were prohibited from telling the truth at our trial. So what that means, it's secret squirrel stuff, I guess, mystery, I don't know. But he didn't elaborate on that. He said we weren't allowed to tell the truth, and then he sat down.
And in Jennifer's statement, she put the blame on school officials, and she said we were not told to take our son home that day. But testimony in the trial, they were told to take him home. They pushed back, and school officials said, okay, we'll give you 48 hours to get him help. That also was, that struck me.
Do I have to tell you to be a parent? Do I have to tell you, he has a gun? They may not have. You knew you bought him a gun. You don't open up a bag, look in the bag. See, that simple thing, 4 people would be alive. You don't do anything, nothing, to try to mitigate any of that. You are a parent. You quit putting that responsibility on somebody else. It's my responsibility, once again, until they get to 18 years old. Every sin my kid commits is mine, right? That was a sin. That's the highest sin you can commit. And you sit there nonchalant. It's okay, right? You got what you got, and it did not violate the law. The 10 to 15, the Tanner rule applies. They'll be okay.
All right, and we will be speaking soon with our Andres Gutierrez, who is live at the court in Pontiac, to hear from him firsthand of what that was like today. Incredibly emotional testimony. We heard from 6 direct family members, from parents, from siblings. Really difficult statements to get through. And let's check in with Andres Gutierrez now. Andres, just kind of bring us through what happened today from your perspective.
Mueller, you've been representing the family of Madison Baldwin. What was it like for you sitting through this courtroom, through the testimony, listening to it another time?
It was gut-wrenching to hear Madison's mom, Nicole's statement, and the statements of the other families. And when you contrasted that with what I consider to be callousness and deflecting accountability by the Crumbleys, that whole scenario was it was hard to hear and hard to get through. But just the emotions of the victim impact statement was so powerful.
What about the Jennifer and James both speaking there at the end? Do you think they tried to show any remorse there at the end?
I think James tried to show more remorse, or at least appear more sincere. I don't know that Mrs. Crumbley, frankly, has much in her, and I think that unfortunately is the experience that her son received in growing up. If those are your parents, you come up kind of what your parents raised you.
Do you feel the sentencing of 10 to 15 years is appropriate here?
Yeah, I thought the sentencing was appropriate. I think the court understood that there are 2 purposes, not just to punish, but to act as a deterrent. And the higher end of the sentencing hopefully will send a message and act as a deterrent to other parents. It's not just about gun safety, but it's about recognizing mental illness in your children and taking the appropriate steps.
What's next for the families that you're representing?
We're still in civil litigation in the Court of Appeals on our federal lawsuit, and we'll continue to do that. And when the decision comes back in our favor, I'm sure, then we'll be able to take discovery and put the school district employees under oath and get the questions answered that the families want about exactly what they knew and when they knew it and why didn't they do more.
The prosecutor has in the past said that she's not going to go criminally after the 2 employees that testified who received those proper statements, but do you feel like she should change her mind here?
I think if you're holding the parents accountable for what they knew and didn't do, I think that should apply equally to school district employees. But I will say, Prosecutor McDonald did what she did and needed to do to get convictions and to hold those folks, the parents, responsible, so I don't second guess her decisions.
Thank you, Mr.
Thank you. Appreciate it. Thank you.
So again, the judge handing down the sentence of 10 to 15 years in the state of corrections, the corrections department, for both James and Jennifer Crumbley. And she, during her sentencing, said that this was not about bad parenting. It is about the fact that there were several opportunities that were knocking at the door and that the parents never took those opportunities. And again, this to act as a deterrent for other parents out there. Back to you guys.
All right, Anders, thank you for that update live in Pontiac. So bringing it back here with Rick and Lillian, you know, let's go through. I want to mention some of the things that were said from those victim impact statements. Nicole Basole, Madison's mother, Madison Baldwin's mother, in every sentencing, she is the first to speak. She delivers incredibly emotional testimony. And what was so interesting and heartbreaking in today's testimony was she compared and contrasted her moments as a parent to their moments as parents on the day of the shooting. And that was so unbelievably effective. She said, when you were inconvenienced to go to school to meet with the guidance counselor, I was rearranging my schedule to get her oil changed for the first time. When you texted the shooter, don't do it, I was texting her, I love you, please call me back. And then she said, when you were hiding, I was planning her funeral. And that was just a few. There was maybe 12 examples of moment to moment comparing what a loving parent does to what a negligent parent does.
Yeah, it was very powerful. She also talked about identifying her daughter at the morgue when rigor mortis had set in. It was gut-wrenching, very difficult to hear, but you know, I think necessary to say.
And another thing that's so striking from these families are the siblings.
I know.
Siblings, it breaks your heart. You know, in one of those examples, she said, while you were driving home to look for the gun, I was telling my 11-year-old that her sister was gone forever. I mean, that's just, it pierces you so deeply to think of what these siblings are going through. These were children too.
Yes.
I know.
How do you accept that reality as a child?
You can't. Bathroom where they put everybody on the chain, and with Justin Schilling was killed, the other boy was not. He was on the text chain with his sisters and his parents. So it's an impact, right? It's an impact forever. These children are going to need something, right? We're going to have to come together as a nation, as a world, to embrace this so that we can try to at least show some kind of compassion and understanding, right? And help try to love on them. How do you recover as a sibling? The room I shared, the room I went in, I can't do that because you chose not to do what you were supposed to do as a parent. It's not about being a bad parent. It's about responsibility. People keep saying, oh, parent, don't make it about parenting. It's about what you're supposed to do. That's your child, nobody else's. Open the book bag. Take him home. That's it. You didn't do it, and you were convicted.
It's just absolutely heartbreaking. We also heard from Raina St. Juliana, the older sister of Hannah St. Juliana. Hannah was the youngest when she was killed in that attack. She was 14 years old. She said, you know, she missed out on so much of her high school experience. She was just starting. She was a fresh, young high schooler. It doesn't make sense. It really doesn't, and it's just it's just so difficult. We heard from both of Justin Schilling's parent, Jill Sove, and Craig Schilling. And each parent approaches this differently. Each person processes this differently. Steve St. Juliana, Hanas' father, he came in with a lot of pause. He came in, you were just waiting on bated breath to hear what he was going to say, and he just kept saying, I am a shell of a person. It's so difficult to hear this, but also so important to hear this.
Yeah, there'll be a time when the support that he's surrounded with now, based on the contemporaneous, events, the friends that are around, the family that are around, there'll be a time when that dissipates, when he's alone, alone with his thoughts, alone without his child, and that'll go on, for the rest of his life. So it's to say, there really are no words to describe, the totality of the devastation that occurred and continues to occur. And one of the things that the judge did in her sentencing was she also personalized the victims in her sentencing, and she made note of the 7 victims of the shooting who didn't die, but she went through each of the victims who were killed personally by name, and she said Madison had a kind soul. She said that Hannah had a beautiful smile, that Justin was a mentor and a leader, and that Tate was going to offer his skills as a football player to a major university. So all of that is now gone. And the judge, I think, did an excellent job of being professional, scholarly, yet empathetic in her sentencing, to make sure that she did acknowledge the families and the hardships, and also went through and listed the details that allowed her, in her estimation, to upwardly depart.
It was the first time we heard from her really about how she feels about this.
Catastrophic.
That was profound.
It was catastrophic.
That was profound.
What she said. She said it was catastrophic, this behavior. And she's a human. We're all human. It impacts each one of us sitting here, right? It impacted her because she had to see it all and hear it all. She did the best she could. She came up with a sentence she felt was appropriate. That's her job.
She specifically addressed the defendants and said, discounted their statements and their blame on others. And she said, James, because of you, there was unfettered access to the gun. She said that you ignored his pleas for help. She said to Jennifer, simply, your response to your son was pathetic. That was what the judge directed to Jennifer. So strong words, compiled with empathy and a heartfelt, emotive plea to the victims and their families, that she understood what they were going through as best she could. Although she said nothing will bring you solace, and these sentencing won't. She said that it's not my role to be sympathetic. It's not my role to be influenced by the media or any of the pressures. I'm going to give my sentence based upon the law and the trials and the evidence that I've adduced, and it's 10 to 15 years for both defendants.
Rick and Lillian, thank you so much for being here.
Thank you, Meredith.
We are going to continue the conversation in just a few minutes here on the stream. Stay tuned.
You know that what my son did, I was not aware of, or that he was planning it, or that he obtained access to the firearms in my house. There was absolutely no evidence that suggested that. If I could go back and do things differently, and maybe none of us would be here today. So again, I ask Your Honor to impose a just and fair sentence based on the truth.
And we just heard from James Crumbley at his sentencing. This finished not too long ago. We know that James and Jennifer were sentenced to 10 to 15 years in prison for their role, and they were charged with involuntary manslaughter for the Oxford High School shooting. Still with us are Rick Convertino and Lillian Diallo. Thank you both so much for being here. So speaking of fair and just sentencing, as James just mentioned, do you think this was a fair and just deliverance today?
Absolutely, I do. I think it was, it's the right sentence given the circumstances and the magnitude of the case. I think the judge defended her sentence on the record by laying a foundation for the purpose and reason why she upwardly departed, which will be an appellate issue. I think it's bulletproof. I think that the facts and circumstances demanded a sentence that was upward departure from the guidelines, and the judge did a good job, and the prosecution as well, in outlining why in their prosecution memorandum, sentencing memorandum, which was lengthy, detailed, and provided external evidence. So yeah, I think it was fair and just and appropriate, and I'm glad that the sentence was what it was.
As we were listening to Judge Matthews in her final statements before she delivered the sentencing, Lillian, you called it. You said she's going to go
up
above.
Oh,
Why
yes.
do you feel that way, based on what she was saying?
Because you could tell. You know, she said that the guidelines don't take that into account, what you did, what the actions were. I'm like, uh-oh, it's going up, right? And is it fair and just? Well, the judge said it was. She justified it, and that's the sentence, period.
In both of your experience, Lillian, we'll start with you. How often does a judge go above the guidelines?
Well, I don't see it in my cases a lot, right? Because usually my numbers are so horrendous anyway. But, you know, you can do that. And these facts are so different, so horrendous, so egregious that you can see it happening. So, and when you have a set of facts like this, you can see it.
Yeah, I had a case recently where the where the judge did exceed the guidelines.
Rick, we do have to just pause right there. We're going to toss to our reporter Andres Gutierrez, who is at the courthouse with Attorney Ben Johnson. Let's hear from him.
I want to ask him, and then I'll get out of his hair if he wants to do his own. I want to know if he wants to do something, or if he wants to do his own thing. Thank you, ma'am, very much.
Yeah. So for the time being, the families were in the courtroom there with the prosecutor after the sentencing was handed down. But in the meantime, I'm with Ben Johnson, who's been representing some of those families. Then the judge went over the guidelines, 10 to 15, what the prosecution was asking. What do you make of that?
Well, I think Judge Matthews, who was a great judge, great experience, gave her multiple reasons as to why. And the primary reason that she talked about was just this insurmountable loss to each family times 4, right? So, and what you have to do, and I'm not a criminal lawyer, civil lawyer, but when you make an above the guidelines type of a finding like she did, she has to put on the record her factual basis for doing so. And Judge Matthews, I thought, did an incredibly gracious and wonderful job of explaining exactly why she did what she did.
Both parents there, James and Jennifer Crumbley, when they spoke, they said they would place a lot of blame on the school district that you're going after.
Right.
What do you make of? What do you think about that? Are they going to continue shielding behind governmental immunity here?
Well, the school district continues to, of course, try to escape liability, right, because of governmental immunity, protect the guilty, as I call it. And the fact that the Crumbleys agree with me, it means nothing to the families of the victims, right? So it wasn't very helpful, in my opinion. Today was for the Crumbleys to be held accountable. I personally would have thought it would be better that they accept responsibility and apologize for the role they played, as opposed to saying, I still did nothing, and the school district is hiding behind, which, again, I agree that they are. I don't think it helped them today. Today was about their accountability, and they still don't want to admit their role in what clearly was their role.
How does this all overall help your case moving forward?
Directly, it doesn't per se, in the sense that this is criminal and mine civil. But I think that the more that the public hears and sees the coverage and hears about the facts, and they get to see all the various people that were in play here that made huge mistakes that could have prevented the shooting, and everybody agrees that the school played a role, including Sheriff Bouchard on the night of the shooting and Prosecutor McDonald from the night of the shooting. Now, that doesn't mean there's criminal charges necessarily, but they clearly played a role, and that's exactly what we're going to try to hold them accountable for.
What's it like for the families who once again have to go through this during the civil side?
It's impossible, right? I mean, how can you sit there and listen to these folks try to defend themselves when they be convicted by 2 different juries, 24 people, right? And then basically try to escape any culpability and acceptance of their own role. It has to be just virtually impossible, and my clients have just shown such incredible class to be quiet, be able to speak and address the court when it's appropriate, and then say nothing when it's not. But to sit there and listen to the Crumbleys defend themselves today, despite their convictions, it was unspeakable.
Ben Johnson, thank you so much for your time. Appreciate it.
Appreciate it.
All right, and we'll send it back to the studio.
Thank you, Andres. And we understand that we're going to go speak to, we're going to hear from Craig Schilling, the father of Justin Schilling. He's speaking with media now. Let's listen in.
The opportunity you were looking for? Do you feel like she heard it, especially given what she said later?
Yes, I wanted to make it clear, you know, in my impact statement that I was really showing the differences of what a mom was doing versus what somebody else was trying to do to cover up what they were doing. I really wanted to get it out there as a mom that, you know, you don't have the choice to look away, and I felt like a lot of the times during this trial they were able to look away, and us as parents, we can't. You know, we have to find those answers, and we have to keep pushing on.
Nicole, it's the second victim impact. How difficult is it to stand up there and express yourself like that?
I mean, it's a difficult, they were both difficult. They were both difficult in different ways. First one, obviously, I was very more stronger, and I was determined to get through it the way I wanted to. This one, I was a lot more emotional because I put myself in, you know, I'm a mom, and, you know, and even with fathers, this is, what would I have done if it was Madison? You know, just different things, and yeah, my emotions came out a lot more in this one because it's heartbreaking. It's heartbreaking to see that family do this.
Nicole, your reaction to the sentence?
You know, I thought I'd have a different reaction. I thought I'd be a lot more emotional, and it was just, that's what I hoped for, but I think that's what we've hoped for so long, that it was just that next step to really go into the next direction of, we can do this, us 4 families, we can do this, and we can take the next step down that we need to in regards to the school.
What is the next step? Obviously, suits have been filed, but what all are you hoping for?
Accountability for the school, absolutely, and we're not 4 families to back down.
Civil and criminal as well.
Speaking their statements. Sorry.
That's right. Just criminal as well. There've been kind of conversations about.
There's obviously conversations about criminal, but you know, we all obviously need the facts and the evidence to prove that. But us as families, we'll do what we need to.
Sorry, thank you.
What do you make of James when James called out the school, and he called out Buck in particular? What do you think about that?
Unacceptable. Absolutely unacceptable.
He turned around. Do you think he was going to say something different, like more heartfelt? Did he speak directly to the parents?
No. I mean, we didn't expect much. What they said was another way for them to play victims, and what we said was how we felt. We wanted to show them what we felt for that time being, and that we're going to continue to feel.
To finish on the question that I think Charlie was asking you also, when James Crumbley was almost trying to align himself with parents that want the truth, did it seem like there was a little bit of quite the audacity that he would take a moment to do that?
I mean, I felt it was a little far-fetched. I mean, I don't think that was necessary, you know, for the truth, because if he wanted the truth, he would have been speaking the truth the whole time, and you would have remorse the whole time, and we shouldn't have to have that at the last part of this.
Regardless of what was or was not said in that particular meeting, this was still just yet another attempt to shove the responsibility onto somebody else. It was consistent through the whole trial up until his very end, last statement. It wasn't me, it was someone else.
What do you think this case means to the outside world? What can the world learn from the unfortunate tragedy that you went through, and now really 3 guilty convictions or trials?
I feel that.
Can you come to the mic?
I feel that there isn't much that the world really needs to learn about this. I mean, I feel that it's all basic information that any parent already knows. The level of responsibility, this only shows that this is a real thing, and the sentence was fair for it. I mean, I feel like it could have gone more, even, you know. I mean, but I mean, it's pretty cut and dry that you have that level of responsibility by having children, and that you have to act with that responsibility.
Thank you.
Thank you, guys.
Thank you.
Your patience with all of us and giving us the criminal justice. And I appreciate that.
All right, we just heard from some parents there, from Madison's mother, Hanas' father, and Justin's father, just their reactions to the court. What did you feel listening to that, Lillian?
They have such grace. They're graceful, right? She's like, I thought I would feel different. I mean, you're just trying to get through it, not over it, right? And look, what Justin Schilling's father said is, you know, you need to stop hiding behind certain things. Ben Johnson said it. I never heard it said like that, though. It's to cover the guilty. It's to shield the guilty. Governmental immunity, qualified immunity. So, you know, if we have to be responsible for our actions, why shouldn't you?
Mm-hmm. And something Justin's father said just then was that this isn't, you know, this is common sense. There's nothing special about this entire situation. It just took common sense and just general caring and good parenting that could have prevented all of this.
Yeah, I don't even think it would rise to the level of good parenting, just you know, average parenting. I mean, your concern is for your children and the safety of your children, and if you feel your child is having a bout of mental illness that needs to be addressed, to ignore it over and over and over, and to put your head in the sand, I think is the only. This case will not. I agree. This case will not be a deterrent. If you are a Jennifer and James Crumbley type of parent, there's nothing that's that you're going to read about or see about, and that you are going to even think remotely it applies to you. We heard them say over and over they're good parents. Jennifer said she was a hyper-vigilant parent at her trial. So you can't get through, you know, to stupid. You know, and there are people out there that this case will have absolutely no impact on, and the people it will, it needn't. So, you know, but I wanted to talk about, Lillian just raised governmental immunity. You know, I know Ben Johnson. There's absolutely no backup in Ben Johnson, and so his pursuit of this will be thorough and exhaustive. So if there's anyone that can pierce this governmental immunity, I think it's him and his team. But governmental immunity is it simply is it's ancestral. So it's something that is historical in protecting, you know, in Old England, the king from charges, and it's come down in our common law to protect. In this case, it's complete immunity, protecting the school officials and the school board. There's qualified immunity, which protects police officers and for their actions, but they have to overcome, the prosecution would have to overcome the qualified immunity to charge and convict a police officer, for instance, to show that their actions were outside of the scope of reasonableness given the totality of the circumstances at the time. But the immunity that the parents are facing against the school board and the school district as a whole is different. That's complete immunity. That's a uniform protection of the acts and activities of the individuals under the penumbra or umbrella of this immunity. So it's very difficult. There's case law, exhaustive case law on it that is years and years and years as precedent to overcome. But I sure hope they do in this case. This was egregious. What EJAC did in that meeting, and the other counselor did in that meeting. I mean, they just and the teachers. It was just a push on, go ahead to get along, kind of move the student out of our purview and pass him on to. We don't want him being home alone, so we'll put him back into school, keep him in. I mean, it was just a historic failure on many levels, and I hope they are called to address the liability on this case.
All right, let's hear once again from Judge Cheryl Matthews when she addressed the defendants in the sentencing.
Opportunity knocked over and over again, louder and louder, and was ignored. No one answered, and these two people should have and sure didn't.
Opportunity knocked over and over. She did not mince her words today when addressing the defendants.
She did not, and that's what we've been saying. You had so many different opportunities to stop this, right? And so that's why I really hope the parents can get some kind of redress from Oxford, right? Because at the end of the day, you have a fundamental responsibility for the students and their safety and their welfare and their education, right? So in that meeting itself, he's looking for bullets the day before. You know that he's drawing a picture of guns, the day of, and the thoughts won't stop. Open the book bag. So, I mean, we had a case, and it's called Monell liability. Monell, where we were able to overcome in federal court a police officer's qualified immunity if they do certain things. So Monell liability should be something they look at.
Yeah, Monell liability is difficult to achieve. And Monell liability is the liability of the institution for failure it's a plan and policy of the institution or an ignoring of the behavior of the subordinates in the institution or the organization that allows for, under Monell, which is a Supreme Court case, for them to be exposed to liability. So, well, kudos to you. That's a tough hill to climb, and I hope that Ben Johnson is able to do that in this case, because there are a lot of people in that school district who should be held accountable. Both the teachers, the counselors, everyone who is along that food chain. There were emails that were passed back and forth internally that we didn't hear about, that you'll hear about in the civil case if it gets that far. So I'm hoping that even statutorily, that the House of Representatives in the state of Michigan can pass something that will allow that veil to be pierced.
And quickly, Rick, 10 to 15 years, what factors determine exactly how much time they're going to serve?
I'm going to pass it to Lillian. She's better able to do that in the state system than I.
10 to 15 is what the minimum is. 10. You don't, unless they bring back good time, right? In federal, it's different, right? You get so much time and credit. In the state system, since truth in sentencing was passed, you are going to do a minimum of 10 before you can hit parole. And because it's so close to the top of their guidelines, they may come out in 10, they may come out in 12, but 10 is the minimum they are going to do every single day unless something changes. in the law right now, every day, up
Yeah,
to
in the
him.
federal system, it's similar, although you get 68 days a year for good behavior, and you can get some allotted time for programs and educational opportunities that you take advantage of when you're incarcerated. But in the federal system, it's similar. Your time is your time.
So we may see some of those elements factor in as well. Rick and Lillian, thank you so much for being here today and for offering your insight. We really, really appreciate it. Thank you. And to recap, the Oxford high school shooter, the shooter in that case, has been sentenced to life without the possibility of parole. His mother, Jennifer Crumbley, has been sentenced to 10 to 15 years in prison, and his father, James Crumbley, has been sentenced as well to 10 to 15 years in prison. They both will get credit for the 800+ days of time served so far. And before we finish, we want to remember the 4 students that lost their lives in the Oxford High School shooting. Senior Madison Baldwin, who was 17 years old at the time, Junior Tate Myers, who was 16 years old, Senior Justin Schilling, who was 17, and freshman Hanas St. Juliana, who was 14. We do want to hear from Prosecutor Karen McDonald at this time.
About the no contact order, and you guys are going to be filing a motion about that. Can you explain what that was kind of about in court today?
Yes, I believe the argument is they want to be able to stay in contact with their son and with each other. We maintain that we are going to take the same position we do in every case, and the Michigan Department of Corrections has a no contact between co-defendants. So
that's they can't contact each other or their son?
the judge hasn't ruled on that yet, so she held that matter in abeyance. We think the Crumbleys should be treated just like any other defendant.
I have a question. When Raina St. Juliana was speaking about Jennifer Crumbley's statement that she wouldn't have done anything differently, there was some kind of reaction from the defense table that she remarked on. She said, "Don't eye roll, it's on video." Who was rolling their eyes?
She made the statement to one of the attorneys at the defense table.
So you had a question?
Yeah. Did it seem like James and Jennifer Crumbley, maybe they realize it and just don't want to take accountability for it, but that they were still saying that they were sorry, but not for the right things? It seemed like, and I think Mark, you mentioned also, and maybe you, Karen, also, we're still trying to suggest that other people were to blame. Now they're trying to somehow align themselves with the parents on going into the school. And did it seem like that did them any favors there?
I can tell you what I think, and I can tell you what the victims remarked to us after, which is, and I pointed this out in court, feeling bad is natural, and we don't dispute that they feel bad. That's not what's important to victims of crime. And it's an essential part of our criminal justice system. The sentence should be fashioned in a proportional way, but what they want and need most of all is a remorse, which means acknowledgement of the wrongdoing and some sort of reconciliation or apology for that, and that didn't come. So, I'll leave the Crumbleys to their own statements, and I agree with Mark, it's disappointing.
I have one other question. On the depiction of the phone calls, Mary Ellen Lehman said that it's basically just venting and frustration and not an actual threat. What's your reaction to that?
I think responding to that would somehow give validity to the statement, and I don't believe there is one, and the statements speak for themselves.
If your son is not a co-defendant, and maybe this is something to be decided later, but James and Jennifer are co-defendants, we know that for sure, correct? The question is whether their son is a co-defendant. Are you concerned that they may have contact with their son down the road and perhaps try to bend him in any sort of way for appellate reasons?
Well, the reason why the judge held that in abeyance is because it was a late objection, and the judge made note of that. So what we're going to do is coordinate with the Michigan Department of Corrections so we can review their policies as well, because he is a related defendant and is a bit of a unique situation. So we want to make sure that each defendant is treated the same as any other defendant in any criminal case. So we're going to ensure that happens.
And I want to make one point on that. The defense stated that they have a constitutional right to be a family. And the parents in that courtroom have been deprived of their constitutional right to be parents. And so that matters.
I can't imagine the pressure your office has managed the past few years. Sigh of relief tonight?
That's a good question. I know that we did the absolute best that we could, and I know that the people sitting in that courtroom, they know that how hard we worked and how dedicated we are to not just a verdict that would appease or make them feel even a little bit of acknowledgement, but also a fair and just prosecution. But it's really difficult, and it always has been for me to take a moment and talk about how hard it was for me or for us. And I know Lieutenant Tim Willis feels the same way, as well as Special Agent Brett Brandon and Mark, of course, and our entire trial team. It's really hard to have to remark about how hard we work and how hard it's been when you're looking in the eyes of these parents every day who get up in unbelievable pain and grief and see this play out every day, and they still go on. And so my focus is there.
Do you think that you've changed the way the country now thinks about parental responsibility because of your case?
Well, Charlie, I want to thank you for a story you did that meant a lot to me and the people on our team when you interviewed local gun shop owners who said that there was a rise in cable lock sales after the verdict of James Crumbley. And I can tell you that that was a moment of peace, and that's what we're here for. However, most parents don't need a message like that. Most parents don't need to have a message sending that don't buy your son who's exhibiting signs of distress a 9mm deadly weapon and make it accessible. Most parents, most of us, don't need Karen McDonald or Mark Keast or anybody to tell them that, and they certainly don't need a jury to tell them that. However, I think it's the entire tragedy and how it unfolded and how it occurred does bring awareness. And you know, this is only the beginning. I've committed to really address gun violence like it should be addressed, which is a public health crisis. And access to weapons is only one thing. And we have a lot more to do to educate the public on how to prevent gun violence, because there's a lot we can do way before somebody gets their hand on a weapon, way before somebody even ends up in a state of crisis. And that is what I'm dedicated to doing going forward.
You said of the verdicts, you know, this was an egregious case with egregious facts, and that those were precedent setting. You know, what precedent does this sentence now set?
No, I actually don't. I don't really acknowledge it's precedent setting. There's a difference between precedent setting and rare. And this is really a rare set of facts. It really is. I think nobody standing here who's listened to any of it would say this is something that we see in the course of what we do. This is rare. This is egregious. And 2 juries agreed, the judge agrees, and I think most of us know that you have to exercise ordinary care, at least to prevent other people from the dangers that you know are foreseeable.
With the new safe storage law that recently went into effect, would a case like this, and God forbid it's never a case like this, but a case where a child gets a hold of a gun and causes harm to someone else or themselves, will it be easier, because obviously this was a monumental task for you guys to try these cases, but will it be much easier to prosecute individuals who are irresponsible with their firearms?
You know, I think the thing I'm focused on is a different question, which is what and how much it will do to prevent, right? So that we don't have to assess whether it's a more useful tool to prosecute. The safe storage law is just bringing awareness so that we can prevent access to guns. The #1 cause of death in this country is gun violence to children. It's the #1 cause of death, and over 50% of that is suicide. So access to weapons is key. It's not everything in prevention, but safe storage is definitely critical. So
There is a legal component to it, though. I mean, and so sometimes the message is sent with that legal attachment to it. Do you think that awareness of knowing that they can be charged, obviously will keep down the number of cases that you get, but may also inspire people to make sure they're not on the other side of the law?
I absolutely think it will inspire people, educate, and they're more conscious of it. This type of set of facts, though, is so rare. It would be, you know, a violation of your duty to secure your firearm, and all of the other things that made it foreseeable that a death or serious harm would occur, which is so rare. But in general, yes, this is part. It's now a law, and most of us want to follow the law. So I think it's important.
One more question. Anyone?
Your message to the community as you've been shepherding this for the last 2.5 years, do you think that this will be the ultimate deterrent for the community with this?
My message to the community is don't look away. These were tragic and awful deaths and what these families have gone through, and it is preventable. It is preventable. That is my message. Thank you.
Thank you. Sorry.
Yeah.
Thank you. Get some through.
All right, Oakland County Prosecutor Karen McDonald offering some comments there after the sentencing hearing. So Rick and Lillian still with us. Thank you both so much for being here. Really, you know, so much of this is about gun violence in this country. What do you make of what she had to say there, Rick?
I think the case is a unique and distinct set of facts that will separate it from average cases that occur regarding guns and children who handle guns. So I don't think that this is going to have necessarily a deterrent effect nationwide. I think it'll wake people up. I think people will pay more attention. I don't think that, like I said earlier, parenting, average parent would be tuned into this and would have easily prevented this, I think. So I don't think it's going to have monumental behavioral impact on the country as a whole, but clearly that the Prosecutor McDonald's quest against gun violence is important, and I think it's going to make an impact here in Michigan.
And to follow up on something you just said, a reporter there asked Karen McDonald, Lillian, about what sort of precedent will this set, and she said this is not precedent setting. This is rare.
I agree, right? But I think there are going to be forces that try to make it about one thing versus the other. Oh, they're going to come for your guns, or no, they're not. We're going to keep our guns, but you have to do it the right way, right? That's all. Safe storage. That's it, really. And there were, like they said, so many different opportunities for the parents to just do anything with this gun. They were in the best position because they knew they had those guns. And they knew they had gifted their son a gun who was having some kind of issues and life challenges, right? So, will it move the needle? I don't know. But I know we'll get more rhetoric. We're going to have people using this problem to raise money, saying, oh, they're coming for your guns. Don't give them your money. Keep your money in your pocket. But no, I really think that these facts were very particular. I'm not seeing something, this many opportunities to stop something in a while. The case I had, there was one opportunity. This case, there were at least 4 that I remember where you could have stopped this, right? So.
And, in your experience, both as, attorneys and just in life, do you feel like justice was served today?
I do. I sat through both trials in the Miller hearing. Every minute of both trials. I think the prosecution did a fantastic job of presenting its case in a objective and yeoman-like way. I think the evidence adduced at trial was overwhelming, and clearly the prosecution proved each element of each count beyond a reasonable doubt to not only one jury but 24 individual jurors. All stood up and recognized their individual verdicts and collective verdicts at the end of each case. I think that based upon all the facts and evidence that was adduced in the prosecution's memorandum, sentencing memorandum and the pre-trial report, I think that clearly In my estimation, justice was served and the sentence of 10 to 15 years was fair.
Your thoughts, Lillian?
I'm just a defense attorney. I don't pass sentence, so it is what it is, right? 10 to 15, the judge felt it was right. Okay.
As a mom, perhaps, as a parent?
Yeah, but as a parent, yeah, I would think that if I lost my child to something that was so preventable, I would want the most, right? But as a defense attorney, I'm like, that's for the judge to pass sentence.
You're like, no comment,
No comment,
as a defense attorney. Well, it's been incredibly insightful having both of you here as a defense attorney and as a former federal prosecutor. Rick Convertino and Lillian Diallo, thank you both so much for being here, providing your insight throughout all of these
You know what,
hearings
Meredith,
and
I just want to say, and I'm sure Lillian will agree, that throughout the trial where you've been present, CBS Detroit has done an outstanding job of covering this case from gavel to gavel, including the Miller hearing. You and Terrence and Shayna and Andres, it was a pleasure and an honor to sit here and work this case with you.
Thank you so much. You know, it really, I feel the same. You don't often get this from your guests, so I really appreciate that, Rick. It's really been a labor of love, something that's been really important to us as a station to air this, as you mentioned, gavel to gavel. It has been. You've been with us every minute of this. There's not been 1 minute that hasn't been shown. It was so important for us to share this with the community because this affected a community right down the street. This affected a community in our state, and the entire nation has been watching this. So thank you so much for those comments.
And it was a pleasure sitting across from you.
Yes, it was, and it was hard. It was the hardest thing I think I've done.
This was
really,
hard.
because you watched it all, but thank you. I appreciate this right here, right? Because we went through it. It was like the birth of a mini nation. It was so incredibly difficult, right? But we did it.
Yes.
And we did it together, so thank you.
Thank you.
Thank you both so much. And to recap, the shooter of the Oxford High School shooting has been sentenced to life without the possibility of parole. His mother, Jennifer Crumbley, has been sentenced to 10 to 15 years in prison, and his father, James Crumbley, similarly has been sentenced to 10 to 15 years in prison. They both will get credit for the 800+ days of time served so far. And we want to now remember the 4 students that lost their lives in the Oxford High School shooting. Senior Madison Baldwin, who was 17 years old. Junior Tate Myers, who was 16 years old. Senior Justin Schilling, who was 17 at the time. And freshman Hanas St. Juliana, who was 14 years old. And we promise we have brought you everything gavel to gavel as it relates to the Oxford High School shooting, from the shooter's Miller hearing, sentencing, to the trials of his parents and their sentencing today. We will have more analysis and reaction at CBS News Detroit.